hear me okay? This is actually not, I don't think it's projecting, right? So the recording is not my responsibility. Tom Garrett arranged for this to be videotaped so that we will have this available for other people in the future who weren't able to be here today but want to be part of the project. So that's why they're here. It is not going on television. You can ask stupid questions. The camera won't be on you, just on us. We can make fools of ourselves, but I do that every day, so it's not a problem. So first of all, I want to thank Eileen Blackwood from the City Attorney's Office, who sort of got this project rolling because she inquired, I think, from Carmen about whether the court might have some pro bono opportunities for attorneys who work for the City Attorney's Office, who have some restrictions on what they can do, given that they work for the city, but wanted to do something to help people. And we talked a little bit and came up with this idea. Some of you may know that I tried to do something similar to this a few years ago when I was in this court that sort of didn't get off the ground. We've tried to change this somewhat to make it more limited commitment and feel less overwhelming to people. So hopefully this will work better than the last time. But I want to thank Eileen very much for coming to us to get this going, and Tom Garrett for jumping in and helping plan all of this, and to our other two presenters here, Nadine and Jessica, who are going to be giving you the meat of what you need to know. So I'm going to start just with a few introductory remarks and then turn it over to all of them. So I want to just remind us all that most of us in this room are incredibly lucky. You know, I don't know all your lives, but I'm assuming that because you're here, you all have jobs, you probably have a home, you probably have a car, you probably have enough food, just because we're in this profession. But I learned when I took this job that there are an amazing number of people in Vermont living in poverty, way more than I ever had any idea about in my protected little world, which many of you probably also live in. For some of those people, it's due to long-term problems such as mental health issues or addiction issues. For many of them, it's a temporary situation due to job loss or a medical problem, due to a partner being incarcerated. Suddenly there's one income, due to divorce. A lot of things can throw people into poverty. But it is shocking when you sit in this job, how many people you see who come through this court who can't pay the mortgage or the rent by such a tiny little amount. You know, they can't come up with that $200 or that $500. Amounts that you just, you know, to those of us who have a good job are kind of hard to imagine living that close to the margin. So many of those people end up here in eviction proceedings, and that's how I learn about them. In this court, of course, there are other courts where I see them in other situations too. But in the eviction proceeding, I want to just briefly tell you what a rent escrow hearing is, because that's what this is really focused on. The first step in most eviction cases is for the landlord to file a motion to escrow rent, also called a motion to pay rent into court. And that often is served with the complaint, along with the hearing notice that the court generates for that eviction, that rent escrow hearing. So it happens very quickly. And there are many tenants who never appear at the hearing, and there's not a whole lot we can probably do about that. But there are many who do come. And what that hearing is focused on is deciding if, when, and how much rent the tenant or tenants have to pay to the court while the case is proceeding. And during that period, the landlord doesn't get the money, the money comes to the court. The kicker is that even if they have other defenses to the case, once an escrow order is issued, if they miss a payment, they do generally get evicted promptly. The law says you miss a payment to the court, basically the next day the landlord can file a motion saying they missed a payment, kick them out. And there are exceptions. You know, there are times when a motion will be filed explaining some reason why the court should use its discretion and not do that. And of course I use my discretion if it's a day late or 2 days late sometimes, but generally speaking, they're going to get a notice, a writ of what's called a writ of possession that I issue that goes to the landlord gives it to the sheriff takes it to them, it gives them 5 days to leave. So even if they have all kinds of other issues that they might raise at trial, they are losing that home in the interim. It's kind of an odd system. You know, I've talked to the legislature, not me, about that, but that's how the law works. So that's why it's so important to have people like you involved at the front end of the case, because it really determines for many, many people the ultimate outcome of their eviction proceeding. Also, most landlords are represented by lawyers and most tenants are not. some statistics that Judge Davenport, ex-Judge Davenport, I guess now, put together, I believe a year or two ago for statewide numbers, showed that about 75% of landlords have lawyers and about 90% of tenants do not. I would venture to say in Chittenden County, it's a higher percentage of landlords who come to court with lawyers. I think in some of the more rural counties, there are maybe less lawyers available and there are more landlords going in on their own. But either way, huge number of tenants unrepresented against a represented party. Lawline does provide a lot of assistance to tenants, helps them prepare forms, but many people don't know about Lawline, and Lawline does not generally provide a lawyer to come to court with you. It helps you outside the court. So this project is intended to get all of you some time in court, as well as helping people who are really on the margins of homelessness and desperately need help. And I'm just going to read you one quote that a researcher in the area of evictions has noted that really struck me. It's a guy named Matthew Desmond who's written a lot about this topic, and he wrote, "Because landlords often turn away applicants with recent evictions on their records, evicted families regularly experience prolonged homelessness and increased residential mobility. When they do locate subsequent housing, they frequently must accept substandard conditions in disadvantaged neighborhoods. Eviction often prevents families from qualifying for housing programs, past evictions and unpaid rental debt being counted as strikes against those who have applied for assistance. Studies have linked eviction to psychological trauma and have identified it as a risk factor for suicide. Recent research has found that mothers who were evicted in the previous year experienced more material hardship and were more likely to suffer from depression compared with those who avoided eviction." So there's a whole panorama of things that flows from this. So if you can keep these people in their homes or help them get time to find a new place before they end up in the streets or in a shelter or living in their car, you will be doing a great service for people. So as you will hear today, there are resources to assist some tenants in catching up with back rent, although that's not always possible. Sometimes the best you'll be able to do is to negotiate more time for them before the eviction happens, or a reduction in the past rent that's due, or a smaller judgment or dismissal of the case if they move out by a certain date, or sometimes even a payment from the landlord if they leave to help them with rent or a security deposit on a new place. Sometimes you will see a flaw in the landlord's case that can lead to dismissal of the whole case, or defenses that can succeed or at least reduce the amount of rent that's owed. Even getting a case dismissed in exchange for the tenant moving out instead of getting a judgment against the tenant may be important, for the reasons I just described in that quote, in helping them find housing in the future. It's really important to know, and you'll hear more about this, that an eviction can disqualify people from getting Section 8 housing, which is very important for a lot of people. So this training is designed to give you the basics that you need to know to understand these issues so you can best advise tenants in that first part of the case. So I do want to make clear, however, that your only commitment in this project is to come to these rent escrow hearings. You're not committing to take on the entire case. Some of you will probably choose to do that, and that's great, but you're not expected to. Your commitment is to assist with the rent escrow hearing, either by advising the tenants outside of the courtroom and having them then come in and appear on their own, or, and I'm hoping most of you will choose this, to actually come in and represent them at that hearing in a limited appearance so that your job would be done at the end of that hearing. You're not committed to keeping the case or filing motions or appearing at a trial. However, we do want you to advise the tenants if they do appear to have defenses that should be raised, answers or counterclaims that should be filed, and so on. There will be a Lawline or legal aid lawyer, I don't know, either one.
Or maybe
somebody,
both.
or both here at these clinics to give you advice and assist you so you won't be on your own, and you can refer people to them for the next steps if you wish to do that. There will also be some forms that Lawline has created to assist you, and I think there are going to be maybe some samples of a couple of them here today. The court is not blessing the forms or saying that you have to use them. They're not mandated. They're samples prepared by Lawline. You can change them. You don't have to use them. You can create your own, but they're there to give you a start. So one other issue that I know a lot of people have asked about, and that is conflicts. Rule 6.5 of the Rules of Professional Conduct, which I handed out, although I don't think I had enough copies for everybody. But if you would like one and you didn't get one, let me know. Of course, you know how to look it up yourself. It creates a special protection for court-sponsored clinics such as this. So it says that you don't need to do conflict checks the way you normally would. Instead, you can proceed to represent these tenants unless you specifically realize that you have a conflict or someone else in your firm does. So if you see them and say, oh, I know who that person is, then you do have to act on that. But otherwise, you don't have to check. So the rule makes clear also that by you representing someone at one of these clinics, you are not creating a conflict for others in your firm. So you don't need to worry about that. You should, of course, review that rule yourself. I highlighted a few things on the copies that I handed out. But that rule is designed specifically to help clinics like this work without making them unwieldy. So thank you all for coming and being willing to do this. I'm really excited about how many of you are here. At the end of the training, I am going to ask you, those of you who feel comfortable committing to the project, to sign up for some dates in February and March, and there's a sign-up sheet on that clipboard right there. And it's going to be 2 Tuesdays, not necessarily every other week. Sometimes the schedule doesn't work that way because of holidays or something like that. But 2 Tuesdays a month is the plan, that we will have a morning dedicated just to these rent escrow hearings. We might slip a few other things in related to eviction cases in there, but the idea is that you'll know when you come. You're just here for that morning. That's your only commitment for that month. You don't have to come every month. If a lot of you do sign up, you won't have to come very often. You're welcome to sign up every month if you want, but you don't have to make a huge commitment to do this, okay? So also, this is a work in progress. We're going to do a trial run later this month without you here, just to see how the morning escrow clinic works without the lawyers. Make sure our scheduling seems to work. But the first one will be in February. We are trying to make this work smoothly, but I'm kind of guessing about how many to schedule, how long you're going to need talking to people out in the hall. So, it may be rough in the first few clinics, I don't know. But I would love your feedback. If you feel like you don't have enough time, we should be scheduling fewer people, or you're sitting out there twiddling your thumbs because half the people didn't show up for their scheduled hearing. I'd love to talk to you at the end of the morning each time and get some feedback so we can adjust. Also, one last thing, because there are some landlords who are representing themselves, we sort of talked about how to handle that. It was my decision that it wouldn't be fair to provide a lawyer for the tenant when the landlord didn't have one. The whole idea here is to equal the playing field, not to shift it. So if there are landlords who are coming in on their own without lawyers, we're going to try to not even schedule them for that morning, so there won't be any confusion about that. But the idea is that we're not going to provide service in those cases. It'll be a fair playing field with 2 people without lawyers. Okay, so thank you all so much for coming. I'm going to turn it over to Tom, and I'm going to listen. Thanks.
Thank you, Judge. I want to thank Judge Tour for being such a great leader in getting this going. This is something that we've been thinking about and talking about for quite a while, and I think that this can be very effective and very helpful for tenants and interesting for you. One of my functions is to make sure that the attorneys that if they want to do this have the support they need to make them feel comfortable in this area. One of the problems with pro se tenants in landlord-tenant law, I think, is that landlord-tenant itself is not simple. It's not easy to explain to people. It's relatively complicated and nuanced. So we're going to use today to sort of make it easier for you to help. And I think please contact me if there are some questions you have or you want to know more about it. There will be forms. I don't have forms today, but there will be forms available, and we're thinking about trying to put forms online to make it even easier. So I also want to thank the Chittenden County Bar Association for being one of the sponsors of this and the Vermont Voluntary Lawyers Project. So thanks for being here. Go ahead.
Tom. My name is Jessica Radford. I am a staff attorney at Vermont Legal Aid, and primarily I do subsidized housing and Section 8 terminations. And as I'm sure Nadine will vouch for me, all of my cases have merit, and so I'm very lucky because it's very rare that I actually end up in this room at all, or if I do, it's just to present a settlement agreement and get the case dismissed. Not always, but most of the time. So the type of case that you're going to be handling is not necessarily exactly similar to what I do most of the time, because I'm dealing with people who have Section 8 vouchers or in subsidized housing, but I am ready to assist you in whatever way I can if you have questions along the way while you're doing this.
Sure. I'll introduce myself. I'm Nadine Seebeck. This is all I do. I do landlord-tenant law. I represent landlords. I've been doing it for over 20 years, and I love it. I absolutely love it. It gets you to court. It's relatively quick resolution. You get to interact with a lot of people. I don't get to deal with as many lawyers on the other side, which would be nice. Sometimes I work with Vermont Legal Aid, and then sometimes some attorneys in various counties will represent tenants. But I cover the state. It is an active area of the law, and like the judge said, you really don't take your life for granted. And I tell my staff that every day when someone's calling you at the last minute saying, can I pay, I don't want to be out on the street. And considering we just went through Christmas, it's always a tough time of year for a lot of families. So I think this is a great idea. I get here a lot. I see Judge Tour a lot and various judges in other counties, and I think it would be helpful to have the tenants be represented, especially if you can help them at the escrow hearing, because I get all the time, you're their lawyer, and I've been doing this a long time, so if they happen to call Legal Aid or David Santos at Lawline or Tom Garrett, and they say, oh, if Nadine's on the other side, you can trust her. She's not going to lead you down the wrong path, because a lot of it is trust. And they come in and they just don't know what they're doing. They don't know and if they have any defenses. And they just like to talk. You try to get a feel for what is going on in their life. If you can send them to services to get some help, whether they need, we have the Housing Resource Center here in Chittenden County, which is through COTS, which they have a back rent program, which has been a huge help. And Judge Tour has handouts on escrow days that gives information to the tenants about the Housing Resource Center, or whether they need services from Howard Mental Health, or whatever the issue of the day might be, or where you can send them. And I was just talking with David out in the hallway. The Veterans Administration, you'd be surprised how many veterans are facing homelessness. And in this state, we have a very strong VA, and they do have funds available. So I've been sending a lot of my tenants who have served in the military to see these groups. So as far as the escrow hearings, I try to be reasonable, and I think what you have to keep in the back of your mind is most landlords do not want to throw people out on the street. It's not their mission in life. They want the rent paid, they want the tenants to comply with the rules. And I find that my clients, and to preface this a little, I do a lot of subsidized housing. I do most of the housing authorities. I also represent a lot of large and small landlords, and they're all the same. They want the tenants to comply with the rules and pay the rent, because they have their bills to pay too. And if you can help them get down that road and get the rent paid, and sometimes it's just not feasible. There's been a loss of job. I have one tenant now who's just getting a double whammy. He's got cancer. He was just diagnosed before Christmas. He's already under eviction. His mobile home's being foreclosed on. So you see some pretty reality, it gets you out there. So it would be helpful if you come and help at the escrow hearings. So at least they can trust someone, or they can talk to someone. And sometimes we're able to resolve the case right then and there. So if there's something that we can work out, great. And we're going to talk about settlements later, but depending on the county, like Judge Tour usually will agree to a 6-month, maybe up to a year repayment, a court-ordered repayment agreement. It depends. So, and some judges won't. They won't do any repayments. And my view on court repayment agreements is that if you give them a shot, if they pay their rent like they're supposed to under the agreement, and they get to stay, that's great. But if they default, then you're entitled to a writ and you protect your client. So there's a lot of nuances, and we could be here for days talking about landlord-tenant, but Jessica and I are going to try to give you the bare bones. And I brought some forms along with me, some of my standard forms and agreements and things like that. So this morning, I think, before the break, we're going to try to cover just the quick nuts and bolts of landlord-tenant law in Vermont. So I'll let Jessica take over.
Okay. For 1 second for the camera woman. Is it okay for them sitting there, or do you need them at the podium?
Yeah, that's fine.
They're
With,
good at the table? Okay.
as long as, yeah, they keep speaking in the mic, that's fine.
Talking to the mics. Get your mic.
So I wanted to start off by just going over the basic governing statutes for landlord-tenant law. You're going to be looking at Title IX, Chapter 137, Residential Rental Agreements. So when I first started out, even now sometimes, I would bring this to the court with me whenever I was going. And you're also going to be looking at Title 12, Chapter 169, which is the ejectment statute. Other statutes to be aware of are going to be Title 10, Chapter 153, which is mobile home parks. We're not going to be going over mobile home park evictions because I think most of those cases end up going to Lawline or to legal aid. And if you happen to stumble upon one, then I would encourage you to approach the legal aid or Lawline staff person who will be here so that they can help out with that.
Yes, the escrow hearing does apply to mobile home parks, so you need to be aware of that.
And other laws that are going to apply are the federal laws relating to Section 8 vouchers, which is a subsidy program through our public housing authorities, and subsidized housing, public housing. But again, those cases will usually end up with legal aid or Lawline. So if you happen to be meeting with a tenant who has a Section 8 voucher or is in public housing, I encourage you to refer that over to legal aid or to Lawline because there are so many different rules that apply to those cases.
Just a big flag on that. So if you see their rent is $150 a month, that is a flag for you that it's some sort of subsidized housing. There's the public housing realm, but then there's also private landlords who enter into contracts with HUD, who we have project-based and rural development properties. So they are scattered. We also have low-income housing tax credits as well. So if you see a lower rent, that should be a flag to you that there's some sort of subsidy involved, which makes it even more important because if they have 5 children, where are they going to go if they get evicted? And you'd be surprised. I remember Judge Katz when I first started. The tenant owed $100, and I said, but Judge, that's 4 months worth of rent. The rent was $25 a month. So someone in subsidized housing can be evicted for $150 if it's a number of months of rent. So you just have to be aware of that as well.
And also there are a lot of remedies that you have available in those cases. And those people, if they lose that voucher, if they lose that subsidized housing, there are no other options. They are going to be homeless for a very long time. And once you get kicked off one of those programs, it's near impossible to get back on. And I can't remember a case where we didn't end up working something out.
She's great. So if you get Jessica, because it really makes a big difference whether, and you know how it is, and whatever practice you do, if the attorney on the other side is cooperative and you can work it out, that's great. If you hate the other attorney and things don't get done, it's the same way. It depends on what your working relationship is with the counsel on the other side.
And it's been my experience, especially here in Chittenden County, that your counsel on the other side when you're representing a tenant is going to be delightful to work with.
Well, thanks, Jessica. Okay.
Of course.
Well, tomorrow, right? And I don't give her what she wants, but yeah.
So I encourage you to look this over before you do your first clinic. We're not going to go over all of the, you can read. So I'm going to turn it over to Nadine to talk a little bit about, is there a tenancy or not?
And sometimes it's questionable, and that should be your first question, is the person a tenant or not a tenant? So since David's sitting here, he should be sitting at a table. I'll let you hand out. Okay. That would be lovely, thank you. This is David Santos from Lawline, Legal Services Lawline, and so he talks with a lot of tenants. So in determining whether there's actually a tenancy, you look at Title IX, and it's Section 4451, and that gives you your definitions. In the context of landlord-tenant, if it looks like a landlord-tenant relationship, it probably is a landlord-tenant relationship. So there has to be some sort of dwelling, and it could be in a hotel if it's more than 30 days. It could be in an apartment. It could be a house. It could be in a co-op, condo, wherever somebody actually rents a unit. The landlord is a person who has control or possession of the unit. The landlord does not necessarily have to be the owner of the property. It could be, I think Judge Cashman gave me a decision years ago, as long as the landlord has a superior possessory interest, it could be under a contract for deed or whatever, that makes that person a landlord. The tenant is anybody who's going to pay some consideration and live in the unit. And it can be with a lease, without a lease. I had a case once where the tenancy was created. They were initially squatters, we can talk about squatters, that's a whole nother topic, which is hot right now. But if the landlord let the occupant put the electricity on in their name, the occupant's name, that created a tenancy. So you have to ask, were you paying for any utilities? Are you paying any money to the landlord? It doesn't even have to be money. You get farmhand situations where they could be working in lieu of paying rent and things like that. So that's how you initially establish the tenancy. Always good to ask the tenant, especially if you're here in court, do you have a written lease? You don't have a written lease? What is your agreement with the landlord? Sometimes you get these landlords, which they shouldn't be doing these things, but your rent is $500 a month. If you do work around the property, I'll pay you X amount of dollars. Those are just complicated things because they never work out, but it is part of the agreement, and whether it could be deemed as rent as well. So usually it's pretty easy to get past the first part of whether there's a tenancy or not.
And just to be clear, some folks will have a rental agreement in which they're supposed to pay a certain amount per month, and from the time that they moved in, they never paid. But they are still a tenant, so long as there was an agreement that they were supposed to pay.
Right, or they could hand over the first month's rent and the security deposit by personal check, and it bounces, the tenancy is still created. So the minute the contract is made, the keys are handed over, and the tenant takes possession, and possession is, that is true, 9/10 of the law, really. If they're in possession, then you have to evict them, and you have to go through this eviction process, which on average takes a minimum of 2.5 months in Vermont to complete the eviction process. So it's not speedy, and I keep working with the legislature to try to speed it up, and you try to slow it down. But it's not a zippy process. So there's a lot of rules you have to follow, and if the landlord follows the rules, then hopefully the landlord's going to prevail. Let's see.
I find that police departments in most cities are going to err on the side of caution, and if a person who is in what appears to be apartment or apartment-like says that they are a tenant, they aren't going to let the landlord kick them out without legal process.
Right. I do trainings for various police departments, and usually get it's a civil matter, and if you're a landlord's attorney and the landlord is told it's a civil matter, then you're going to more than likely be evicting them unless you find some other reason to get around the actual eviction process. So so that's pretty much that. I think you want to talk about self-help evictions next?
Yes, so that brings us right into self-help evictions. So sometimes a landlord will decide to take matters into their own hands.
They do.
Yes.
Not my clients, but they do. Yeah.
So
I would kill them all.
self-help evictions are absolutely illegal in the state of Vermont. Doesn't matter how little time the tenant has been in the unit or how long they've been in the unit, how bad the landlord thinks they are, even if they've gone to jail and they're not actually in there anymore.
That's a good one, yes. They're in jail. Why are they still my tenant? I get that all the time.
Yeah.
I do. It happens a lot.
They still have to go to they have to go through the legal process. And just to be clear, a legal eviction isn't just changing the locks and throwing the person's stuff out onto the front lawn. It could be turning off the utilities so that the person has no water service in their rental unit. I had a case where actually while I was meeting with my client in their apartment, the landlord came over with a chainsaw and started taking down the stairs, the only way to get into the apartment from the outside. Which
What did you do?
Well, I went out on the porch and I said, excuse me. Anyway,
You get great stories, really. You can't make some of this
Really,
stuff up.
really, you do. But that was not in Chittenden County, just to be clear. So,
Encouraging, okay.
so taking away the means of access to the rental unit would be one way of affecting an illegal eviction. Also, denying the person access to their personal property is covered under the illegal eviction statute. And the remedies that you can get for that are going to be injunctive relief, to be able to get back into the rental unit, damages, costs, attorney's fees, which we always like to try to collect on. But I think most of the time here in Chittenden County, no, that's not true. You see more utility shutoffs than just straight up changing the locks around here. And most of the time you'll find that the landlords are going to be pro se who are engaging in illegal evictions. So again, these probably aren't cases that you'll end up with just because if a landlord is pro se, even if they illegally evicted the tenant. Maybe that'll be discussed later. Who knows? Maybe you will end up getting those cases sometimes. But yes, in Vermont, absolutely illegal. It doesn't matter what the circumstances are. If there was a tenancy, they have to go through legal process.
Just on the utilities, because you may get a question about utilities, and the times that I really don't get the utility issues other than if my client is confused. If the tenant moves in, the utilities are supposed to be included with the rent, and the tenant's supposed to pay the utilities. The tenant can't get the utilities in their name because they owe way too much state of Vermont gas, and the landlord says, oh, I'll put it in my name, but you pay me every month. Then the landlord isn't getting the utility payment from the tenant every month, and the landlord decides they're going to shut off the gas. That's a problem because you can't. You've already established that the tenant can have the gas, but they're supposed to pay you back. We'll get it back as damages later. So sometimes landlords get a little confused about what they can and cannot do, and that's your job, is to help them out. And it's interesting.
And one of the areas that I find comes up a lot is, say, the tenant is supposed to be paying for the oil, but the furnace is just not working at all. So I would consider that an illegal eviction because it's not the tenant's responsibility to fix the furnace. The landlord still has to provide the means to be able to heat the unit.
And you do have to be, right, and when you come in and meet with tenants, one thing you need to ask them, and I ask my clients as soon as I take a case, has the tenant ever complained to you about the condition of the apartment, or has the tenant ever given you something in writing that they're withholding their rent for any reason? That should be one of your standard questions you should ask the tenant when you meet with them. Have you any issues with the apartment? Do you have heat? Does the plumbing work? Have you ever complained? And sometimes tenants will give you well, there's a ding in my door, or little things like that, minor repairs. We're talking about the big stuff. A lot of communities have minimum housing inspectors, Burlington, Bill Ward, they do a great job. And sometimes I will call in the housing inspector just to show that there aren't any problems with the unit. Certain municipalities have regular inspections, and the landlords pay a fee every 1 year, 5 years. Burlington, Winooski, and various other areas. The state also has fire marshal's office and other people who come out and do inspections of apartments. So habitability is a big issue, and some landlords think, well, you're not paying the rent, so I can't afford to fix A, B, and C. Well, yeah, you do. You have to fix A, B, and C, and even if you're not getting the rent, you have certain obligations as a landlord. So everybody has responsibilities, and that's one of the keys for the landlords as well.
Walter, you wanted to ask a question?
If the tenant is responsible for the gas or the oil or the electricity in his or her own name and pays the rent but doesn't pay that bill, the landlord doesn't become responsible for heating the apartment, does he or she?
No. The only question becomes in the wintertime, which this issue comes up a lot now, that the tenant's not paying the gas bill and there's a shut-off notice, and the client calls and says, what do I do? Well, either put it in your name or it's going to freeze. Or, case recently, a very unusual case that I have, I filed for an injunction to force the tenant to put the gas back on. That's the only time I've ever had to do that in 20 20 years. You like that, do you? Yes.
No,
So,
we'll
but,
talk about that later.
okay.
By not paying the heating bill, the tenant cannot unilaterally make the apartment uninhabitable under the statute.
Right. Even if, say, the city comes in and says you don't have gas or power, or gas and heat, and or gas and power, if there's children in the unit, they will make the tenant get back on. It doesn't give up their possession of the apartment just because the city has found it uninhabitable. As long as it's not the landlord's fault, they still have possession. You still have to go through the eviction process. So it's
Well, they give rise to an argument that the apartment's been abandoned.
right, and then we try that avenue. But it's, in the wintertime, most landlords will err on the side of caution. They don't want their pipes to blow.
Exactly.
And tenants know that. So sometimes they'll stop paying in the winter months, knowing that the landlord will pick it up, and then we'll get damages later. Like it means anything. So, yeah.
But there are lots of services to help people with utilities, especially in the winter. And so that's a good case to send over to the Housing Resource Center.
Right, and the Housing Resource Center really, they do budgeting, they do a lot of work, and if they can help the tenant, especially with funds, they will do that. And the tenant, and to be clear, the tenant has to have the ability to sustain the housing, so if you have no income coming in and you just don't have the money, they won't be able to assist you. But if you, say, you lost your job or your car broke down, we've heard a lot over the years, you hear a lot every day about why they can't pay the rent. So if they just need a little helping hand to get them ahead, then Housing Resource will step in to help them.
Nadine, do you want to cover notice of termination of tenancy for us now?
So this is big. This is
It's huge.
I'm so glad you're sitting there.
Yeah.
Pass them out. Okay. So in order, yes, please.
Short on
I know. I don't. I have 25-ish, so I think there might be short a few, but you can share, read along. So in Vermont, the first step you have to take as a landlord is you have to terminate the tenancy before you can start eviction under Title 12. So you start with Title 9, and under Title 9, Section 4467, that is your termination of tenancy statute, and this is where you go to if you want to terminate a tenancy. And it gives you all your reasons for termination. And I'll just go down them briefly. The biggest, most popular, I guess, would be non-payment of rent. And in Vermont, you have to give at least 14 days notice. And then under the notice rule, which is a few sections earlier, you have to work in at least 3 mailing days to make sure that it creates a presumption that the tenant actually got the notice. And some tenants will come in and they'll say, I never got the notice, which is always popular. So I tried to give, there's more. So David's going to bring around one of my sample non-payment termination of rent notices. And this is it. This is the notice. So you have to address it to the tenant. It has to be at the reference the property. It has to say how much rent is owed through the current rental period. It has to give an actual termination date. You can't, years ago you used to say 14 days from the date you receive this notice, or some gobbledygook language. The best thing you can do is to put a specific date in. And you count 14 days after the date of your letter, you add in 3 more full mailing days, and then wherever your date drops, if that date drops on a weekend or holiday, you just move it forward. It's always better to have a little more time than not enough. But we'll talk about, Jessica's going to talk later about motions to dismiss, and the first thing that you should look at in representing a tenant is the landlord's notice, because not all landlords comply with the law, and they don't have all the language. And I know you just must just go nuts when you see a bad notice. Never from me, ever, but so you have to make sure the notice is perfect. If the notice is not perfect, then the landlord's got a problem. And so basically, the notice is set forth, and under Vermont law, you also have to give the tenant the right to cure. So you have to tell them, if you pay X amount of dollars by X date, then your tenancy is going to be reinstated. If you don't pay in full, then eviction proceedings are going to start. And that's the long and short of it. So then you can start eviction under Title 12, which we're going to talk about later. But this is my form. I'm going to talk about Fair Debt Collection Practices Act later, but this includes the blurb. So if you are sending a notice on behalf of a client, you have to include it in your notice. If the client is sending the notice him or herself, then they don't need to include it, but if you're trying to collect a debt, then you need to include some language. So I'm not going to read through the notice. It's pretty cut and dry. I put delete my bolded comments because I had a client once who just sent it out with all my notes, and I'm like, so now I have to tell everybody, delete the bolded comments because I just need you to pick how you want to do it. I encourage clients to send their notices at least 2 ways. In Vermont, you can do it first class in hand delivery, first class in certified in hand delivery. Pick at least 2. I encourage clients to get some sort of proof of mailing. You don't necessarily have to send it. Certified, you do not have to send certified in Vermont. Notice is sufficient by hand delivery or by first class mail. The certified days are gone, so those of you who have been around for a little bit longer, you do not need to send by certified mail anymore. But I do encourage my clients to get some sort of proof of mailing. You don't necessarily have to pay for certified mail, but the post office will give you a stamp that you actually mailed your letter.
But Dean, do you sometimes I've sent first class mail and then certified, and miraculously the first class mail one, which doesn't have a receipt, doesn't come back, and the other one comes back unclaimed. I think that can help sometimes that can help show.
Right, I never worry about that. Most of the time I get the certified letter back. As long as the first class does not come back, then you're fine. You'll never get dismissed on that. I have had cases where it's all come back, and then I have to either hand deliver it or send the sheriff over there.
And just because I think you look for it from a tenant's perspective, looking at the non-receipt of notice, if it's been mailed, it's...
Oh yes, and we're going to get to that later. So after the break, we're going to be going over all the defenses that you're going to have, ways to get a case dismissed, because of course that's the first thing we always want to do.
Can I just add one thing here though? Maybe you mentioned the 14 days, and I just want to mention that if you read the statute, there are situations where the timing is different.
Yes.
Usually it's the 14 days, but there are, when it's an unwritten lease and they move there for a certain amount of time, there's sometimes some longer notice period that you have to give.
For instance, if it's a breach of the rental agreement and it's for something other than criminal activity, illegal drug activity, or violence, something that threatens other tenants, then the notice period is 30 days. And if it's a no-cause eviction, then you're going to see 30 days if it's less than a 2-year lease, 60 days if it's more than a 2-year.
Residency.
Right, so there are a number of different variations that you can see on that. And of course, what you're going to see in a lot of cases is multiple notices, and multiple notices are actually permissible. So a lot of landlords who really want a tenant out, if the tenant hasn't been paying their rent, will do a notice to quit for non-payment and a notice to quit for no cause, because even if the tenant catches up and pays their entire arrearage, they just want them out. And so a lot of the time you will see those multiple notices with different termination dates, and that is permissible under the law.
So 1 second, before I lose this thought. So when you meet with the landlord, so if you come into an escrow hearing, you should ask the landlord or the landlord's attorney, well, it's going to be the landlord's attorney, what do you want out of this? Because sometimes my clients will have me send non-payment and non-renewal notices out because they think it's just never going to work. And I can't tell you how many times I've had the landlord withdraw the non-renewal notice if the tenant can get caught up on the rent. So you should always ask the landlord, what do you want out of this? Are they okay tenants? Because if they're good tenants and they keep a clean apartment and they're just having a rent issue, maybe you can work it out and you can save their tenancy. So just because a tenant gets a non-renewal with a non-payment, don't think that's the be-all, end-all. I mean, granted, some landlords are like, I want them out. I'm sick of it. The rent is late every single month. It's just not working out. And they would rather have an empty apartment and pay the attorney to evict than to keep the tenant. But you just have to ask and get a feel for what the landlord wants to do.
Just quickly back to notice. If the certified mail comes back unsigned, are you just popping in the mail the first class, or are you also doing like a delivery confirmation so that when the tenant says, I never got it, you have something? Or does the judge just take your word for it?
I send it first, and certify at the same time. I have some clients that will copy the envelopes to show, but I tend to find that if the tenant has submitted an answer or notice of appearance and the addresses match, then you'll never lose on that.
Yeah.
That
True.
always works great. So I always wait to see what they put down for their address, and if it matches, then there's no way they could challenge that you sent it to the wrong address, or they didn't get it. Or sometimes they will call you once they get the notice, and then they forget that they called you when they got the notice and said, I got your notice, and then they say, I never got the notice. Well, as an officer of the court, you called me afterwards and you said, what can I do about this notice? So it really, it's a case-by-case situation, but I find, and I have some clients that just send everything out first-class mail, like my large clients, we can do that. We don't get challenges really that the notice was ever sent, but the smaller landlords should definitely be doing it at least 2 ways.
Tracking is a big help too, and it's cheaper than certified, and it is the post office saying, we delivered it, we put it in the tenant's box.
Right.
You don't get a really meritorious argument that you didn't get it when it was put in your box and the post office says so.
Right.
And many tenants actually, as soon as they get that notice, feel compelled to text or email the landlord to say, why are you doing this to me? And so that can often foil a claim.
Yeah, we love that. So the other reasons for termination. So non-payments is very popular. The next one is breach of the rental agreement, and that's a 30-day notice, plus you're always working in the mailing time. Unless you get a landlord that actually handed it to the tenant, saying 31 days, you're going to be okay. But you have to always work in at least 3 mailing days. And breach of the rental agreement can be, noise is really popular, drug activity, those are the biggies.
Smoking.
Oh, yeah, smoking is huge right now. So,
Pets that aren't allowed.
yeah, the list goes on and on, so.
So in Burlington, we won't deal with these particular cases. There was a charter change.
Right, I was gonna get to that.
Okay, then
Are we
I'm.
gonna get to non-renewal? Is that what you're going?
Well,
down
no,
that
actually for termination, for no cause.
For no cause.
It's a 90 day.
90 or 120.
Yeah,
Yeah.
so, okay,
Unless
got
there's a
it.
lease. If
Don't
there's
worry,
a rental
Burlington,
agreement-
we're getting to you. We're gonna get to
I just
Burlington.
want to make sure that.
So you have my
Thank
Burlington
you.
is different notes.
We are.
okay?
Proud of it.
The notices, can you have all these different reasons for termination in one notice, or do you have to do
Yes.
separate notices?
I do it all in one. So I'll do the non-payment, and then I usually start the next sentence with, even if you pay in full and stop the termination, you're still terminating for X, Y, and Z. So it's really clear, and I try to write my notices without any legalese. I try to keep it very simple and to the point, but I do it all in one notice, because I don't want to confuse the tenant by sending 2 or 3 notices for different reasons. Then they get really confused, so.
Is a breach of the rental agreement curable?
It depends. Like we were talking about utilities before. If you send warning and they don't put the gas in their name, sometimes depending on the tenant, if the client thinks that the tenant just needs one little push from an attorney to get them to put the utility on in their name, sometimes I will give cure language in the utilities that says if you pay the utility bill and you put the gas on in your name by the termination date, that'll cure it. But you don't see it too often. I think that's one of my only times I give a cure, or if I have a subsidized tenant who hasn't completed their recertification paperwork, I'll give them one last chance to get that paperwork in before they terminate. I think those are the 2 times really that I'll give a right to cure. Otherwise, with a termination for cause, then more than likely they're going, unless you can work something out. I mean, cause cases are tough. I mean, you have to be able to prove your cause case. Criminal activity is, if they're sitting in jail, if they pleaded guilty to 10 drug counts, you got them slam dunk. But sometimes noise, you get a neighbor who's just a little too sensitive, and you never know what's going to happen. So, but for cause, it's.
I'd say for cause, it's
Yeah.
a real waste of time.
Yeah.
Anybody you want to evict for cause, you're better off evicting for no cause.
Right.
Because the second I see a case for cause, I'm asking for a jury trial.
You
We're
did.
waiting
Oh,
for
come
12
on.
months.
And you
Hey,
can.
I want lots of time for them to find a place to go.
Well, that's going to buy them a long time. But
Yeah.
you can ask for a jury trial in a landlord-tenant case.
Think of all the experience you can get.
But if you're representing a landlord, you're way better with a no-cause eviction.
Yes.
You don't have not naming the rent.
Right. Unless,
That's.
don't listen to
It's
him.
true.
So,
Yeah, don't listen
don't
to
listen
me.
to him. So,
No clue.
unless they're with it, or you get the tenant that just moves in and they're tenant from hell in month one.
Yeah,
You have
okay.
a year lease, and the only way you're gonna get them out is with a
If
cause.
they're a tenant from hell, they're probably an experienced tenant too, so if you foreclose them,
Yeah.
you're liable to just find like a world of pain.
Well, they're,
It's true. It's like repeated calls to DFS, repeated calls to the town
Yes.
officer.
Yes.
Repeated calls to the police about alleged harassment. Oh my God.
I know, it goes
Tenants
on
can
and on.
be so evil.
Yes, they
Wait, who do
can.
you represent, David?
I know, jeez.
You know, I was gonna say before, I represent all the cases with no merit.
Yeah,
So
with no merit.
the only reason they have merit is because the landlord made a mistake, or on occasion, the tenant had a little accident with their income and can be fixed.
And
Other than that.
mine all have merit. So I've only actually, I've only lost one subsidized housing case that I knew I was gonna lose in advance. I just felt bad for the guy because he was so slow. Don't deal drugs in your apartment. I cannot win that case, but anyway.
Yes, yes, and legal aid is good about that. They see drugs, then they know it's a sinking ship, and we tend to go. But, I mean, Jessica, and that's why being able to advocate for the tenant or get them services, we just had a case where the tenant owed a ton of money, the management company wasn't keeping up, new management company came in, tenant owed a ton of money. Somehow she manages to get the tenant a Section 8 voucher, and she filed bankruptcy too. But there are certain avenues that you can go down to help the tenant to.
Or we had that one where my person owed over $6,000 and she stayed. Oh,
Yeah, she does pull it out, she does pull it out sometimes, so, but you never know where these cases are gonna go. So for breach of rental agreement, I tell my clients, if you're gonna bring a cause case, you have to look at it and go, does that person really need to be evicted for whatever the violation is under the terms of the lease? If it's some minor dinky violation, you probably aren't gonna win it. It's gotta be something that you look at and go, yeah, that person really needs to move. They have parties every night, they assaulted a neighbor, we get those pretty regularly too. Tenant fights, things like that. A few years ago, under the legislature, and you can lobby. Lobbying is fun. You get to do all sorts of fun things as an attorney. But I represent the Vermont State Housing Authority, so every 2 years or so I get to go to Montpelier and lobby on behalf of landlords. But a few years ago, we came up with 4467B2, which I had argued to the legislature was, why should a tenant get 30-plus days notice when they're engaged in drug activity or they're affecting the health, safety, and welfare of other residents? Why? Because the other residents are freaking out, and these are really tough cases because you have the neighbors who are living in unbelievable conditions while this is going on. So we were able to compromise a little bit, and we passed a 14-day shorter notice period. So if you see something usually involving drugs or violence, then the landlord can give this shorter notice provision. And I specifically, when I use it, which I do use it often enough, I do put this particular citation in that I am using my 14-day shorter notice period. So it's perfectly clear why I'm using that.
How does the notice period work if the notice of termination includes both breach of the contract and failure to pay? Do you have to give 30 days, including the failure to pay?
No, you can do a 14-day for non-payment, and so if you have a regular cause breach case of 30, they're going to terminate after 14. So what I do is I will start the non-payment case, and then if the tenant files an appearance and the case is proceeding on, I'll amend later to add the cause, additional reasons. And amendments are usually, I don't think I've ever had an amendment not granted, ever. So that's what you should do. Okay. Then we have termination for no cause. Some states don't allow for no cause, but Vermont does, and it gets a little confusing. The law changed a few years back. So if you have the first part under C, if you have no lease, and I always get my lease expired from my clients. No, I want to see the lease. And most leases have some sort of holdover provision. So you always want to ask, did you ever sign a lease with the landlord? Because usually there's some holdover provision and it becomes a month-to-month written lease after that. Because depending on what agreement you have, and this doesn't happen very often, I get to talk about the tenant's perspective, but the tenant side is, was there a written lease or not? Because in a no-cause case, that could make or break your whole case, whether the landlord gave sufficient notice or not. So the landlord may not think that there's a written lease, and you go and meet with the tenant and they say, I remember I signed something when I moved in. Can you please find a copy of that? Because if there is some sort of written lease, then it is a different notice period. So when there is no lease, if the rent is payable on a monthly basis, actual notice is 60 days. And what I tell clients, this is the way I do it. If you're on a month-to-month lease and rent is due on the 1st of the month, then your rental period is the 1st of the month through the 30th or the 31st of the month. I know some lawyers will do no causes and they will terminate mid-month or the 8th of the month or some funky date in the month. The way I see it is that your termination date for a no cause should be the last day of the rental period. So if it's the 1st to the 31st, then your termination date should be, say, January 31. And then it's 2 full rental periods. So say, for example, we're in January right now. If you had to give a 60-day notice, I would give the rest of January, I would give February and March, and my termination date would be March 31st. That's how I calculate it. You'd rather be safe than sorry on your calculations.
Although I actually wouldn't try to do a motion to dismiss if you did, 64-day notice and it was in the middle of a rental period.
Yeah,
I shouldn't tell you that, eh?
Eh? She's Canadian.
I am Canadian.
She's Canadian. So, I just thought I'd throw that in. So, but I appreciate that, but I just find that, and then the tenants get confused. Well, do I pay prorated rent? Do I pay the full month's rent? What does the landlord expect? And I just like to keep it clean.
And one thing you will hear from tenants all the time is, he can't evict me, it's winter.
Oh,
He
yeah.
can't evict me for no reason in February. Yes, he can. This is totally urban legend.
And you'd be surprised. Every year, I get calls in the spring. How much rent do they owe you? $10,000. You're calling me now, $10,000? Oh, I thought you couldn't evict in the winter. Who told you that? The tenant. And you believe the tenant. And I get all the time. You can't evict me. I have children. You can't evict me. I'm disabled. Whatever the reason is, it doesn't matter. So they will ask you if they can be evicted in the winter for whatever reason, and your response to them is yes. It doesn't matter what time of year it is, because they all think this. It's incredible. It really has taken on a life of its own.
Children, wheelchair, doesn't matter.
And they swear to me that they read it in the Vermont tenant, the CVOEO book. I call it the Tenant Bible. And I'm like, no, because I know I contributed one year and I put the big bolded letters that said you can be evicted in the winter for whatever reason. So, and then the other part is 90 days. So the same calculation. One thing I will throw out there is, say for example you have a tenant who's in one unit and they get transferred to another unit. How do you calculate the time? Anybody have a thought? So do you start from the first unit, since the landlord is the same, they transferred to a different unit? How would you start calculating the time? Let's see if you're all awake. They're nodding. Anybody? Would you start calculating from they moved into the first unit for your no-cause notice, or from the second unit? And a new lease was signed for the second unit.
Tenancy, the second unit.
New tenancy on the second unit. But I did get a motion to dismiss maybe a year or so ago on that, or maybe 2. It was when Judge Crawford, so it had to be a little over 2 years ago. Judge Crawford was here and he ruled that new tenancy was created. No, your timing was correct. I thought it was a good argument by the tenant. I thought that was, I've been here longer. They should have given me more notice, but.
I would have made that motion.
Yeah, I know you would have made that motion. So, let's see.
So, do you want to get to fair debt collection practices?
Oh, that's an easy one. So before we forget, and then you have when you have a lease, you have different standards. You have a 30-day and a 60-day, more or less than 2 years. So you just have to look at a calendar. You got to look at the lease to do your timing.
What is the Burlington for that fellow over there?
Yes, I'm going to talk about Burlington. So
Okay.
Burlington, if you have a no-cause termination, and there's no lease, no lease. Burlington is 90 days if you've been there less than 2 years, and 120 days if it's more than 2 years. And I can tell you, clients go nuts when I say, do you have a lease? No. Where's the apartment in Burlington? Okay, wow, and they've been there more than 2 years. 120 days, they almost have heart attacks. So, but you have to remember, Burlington is different, and if the landlord is not given proper notice, which you should be looking at the notice to see whether it's good or bad, it is a reason for the case to be dismissed if there wasn't sufficient notice.
How does
Are
that
there-
apply? Sorry, go ahead.
Are there further categories for even longer notice? I thought something
Yes.
about elderly, disabled, or poor. No?
Condo conversions
Ah,
require, I think it's a year or 2 years. Perversely, in Burlington, no written rental agreement, you follow the state statute, 30, 60-day regime, 2 years over or under. And if you pay rent weekly, which I don't understand why every landlord doesn't have rent paid weekly, it's a, what,
Shorter.
15, 7-day
21.
notice?
21 days.
21 days for no cause, regardless of where you are.
Right. So you have to look at, is it week to week, is it month to month, year? Because some landlords look at their lease and they think they can just give the tenant a notice, a no-cause notice, and there's still 8 months left on the lease. Well, it says I can terminate. No, you can't. So there are landlords out there who do that. So that's why another reason you need to really look at the lease and what the agreement was between the landlord and the tenant. So, and you can read the rest of the notice, but I use 4467 all the time, and I've been doing this a long time, because when your notice goes out, it has to be perfect, and I never ever want to make a mistake, because your client will kill you, because especially if you've given 60 or 90 days and you've blown the notice, you're fired, pretty much. So I will still pull out 4467, I will look at it, I will look at everything before I put it in the mail, the notice, just to make positively sure.
One other thing is farm workers. There's a specific statute pertaining to farm workers. I have never seen one in Chittenden County per se, though you might see one from Milton or someplace.
It does happen, yeah.
It has its own notice provision. It's a statutory form of notice. You can't write your own. And it provides for an emergency or an urgent hearing on 10 days' notice, much like a rent escrow hearing, except the farmer, if he can show to the judge that he needs the housing in order to hire a replacement worker, will get a writ and get the tenant out at that 10-day hearing. Not get him out, but get the writ and serve the tenant with a 10-day writ. So that's
It's very
its own
specific.
peculiar animal.
Yeah, it's very specific, but it does happen, and I had a case, right before the law was changed, I had some farmers in Grand Isle County that we had to go through a full-blown eviction. They were going nuts because they needed to get a worker in there, and they went to the Bullises went to the legislature after this case, and they helped get this law passed. So it's a much speedier process. But before I forget, the last part of 4467K, this was just enacted a couple years ago, and if you're talking...
I kiss you for that one.
I didn't want that one. These guys wanted it. But before, your notices had no end date. There was no 3 months later, the tenant hadn't paid, you could start a non-payment case. So what subsection K talks about is that your termination is only good for 60 days from the termination date. So if you haven't started eviction within that 60-day period, your notice is dead, and you need to start a new one. So I tell my clients, you want to play a game, you might want to take partial payments, you might want to dance around, you need to make sure that you start within 60 days. If you, and
I wonder what we'd do if it was a Burlington case and they had to do the 120.
what?
If they had to give a 120-day notice.
Oh, yeah, and then they didn't start it within the 60? Oh, boy, that's a mess.
I've done a motion to dismiss.
But the tenant's going to win every time. The tenant's going to win every time. And the other thing you have to be careful of is you can start an eviction case by serving first or filing the case. So if you're an attorney and you send out your paperwork to the sheriff and your client tells you 30 or 40 days in that, oh yeah, I want to start this case now, you really need to watch your calendar, because if you send out for service first and the sheriff doesn't get the tenant and you get your service back and you look and go, shoot, I'm 62 days and I haven't filed the case, or I haven't made service, let me preface that by saying, if the sheriff hasn't made service and you haven't filed it and you're past your 60 days, you're going to lose every single time. So you really need to watch your calendar to make sure that everything, because what I try to do is I serve a lot first, because a lot of my cases I get resolved without even having to file the case. But if I'm getting close on my 60 days, we make sure that that case gets up here just to protect the client's rights. But that's a tricky little thing, and if you haven't started it within 60 days, it's an automatic dismissal, and how pissed is your client going to be when you blown that? So, okay, what's next?
FDCPA.
So this is Fair Debt Collections Practices Act, Title 15, I wrote it down somewhere, 15 USC 1692. If you're trying to collect a debt for someone, you really need to...
Joe has a question.
Oh, question.
Question, going back in probably to the wrong demographic, but the moving truck is in front of the house, their financing just went down the dumper, maybe, kids are in the car. Can we just move in for a few days before closing, because we don't want the kids to freeze to death in the car, and you let them? How thick a soup have you made?
Not until the closing is done. I don't
Isn't it
advocate
exempt
that.
if it's under purchase and sale contract, the property issue?
Well, the question is it landlord and tenant?
Yeah, it's
You've
not.
allowed them to move in after sale but before closing.
Right, but isn't it exempt, isn't that a situation exempt under the Residential Rental Agreement Act?
I don't think it's under the exemptions.
But it
But there was no rental agreement made, and so it wouldn't be under Title IX.
Unless that they say, we'll pay you $500
Right.
a month until we close, or,
Right.
yeah.
But I'm just going to add here, even if something doesn't technically become a rental agreement, as they were pointing out, if you are the owner of that house now and your deal has fallen through and the people are in and refuse to go, you can't get rid of them without coming to court.
Right. Still a title.
Because, if you try to issue a no trespass order or something like that, the police are going to say no. And so whether it's technically under the statute or not, you've got to come up with some legal proceeding. And this becomes an issue. I mean, I've had cases like this where everyone's scratching their head. Well, they're not really a tenant, they're really a squatter, but they're in there and we need to get them out. And what is the legal process? What statute applies, what common law? It can be very confusing. But you do need to somehow get them out in court and be creative.
Okay.
But you guys won't be dealing with that.
Yeah, the contract for sale is excluded, but you still have to come under Title 12 to get them out for ejectment. So I just handed out real quick, Fair Debt Collections Practices Act. The blurb is in the non-payment notice that you got earlier, but I put this language at the bottom of my complaints. You can just work it in anywhere on your complaints, but anytime money's involved, I always throw this language in because legal aids, well, it's not a new little tactic, but, and they're always trying to come up with something new, so you gotta stay on your game. So if a tenant goes to them early in the process when they get the notice,
I had this case.
I think you will tell them to send something saying, I want to verify the amount of debt. If you don't
It
respond...
was a legitimate question to ask.
Yeah, sure.
Yes.
And it was, if you get, so you send out a non-payment termination notice, and you get something in writing from the tenant asking to verify the debt, you better respond to it.
You cannot file the complaint until you do.
You have to respond to it, so, because they can claim Fair Debt Collection Practices Act issues with your process.
And what that would mean is statutory damages against the attorney and attorney's fees for the person making that case. But would I ever do that to one of my...
Oh, you'd never do that to me.
I would never do that to you. So basically, I've had cases where we've tried to verify the debt and the attorney, misses it, moves forward, what have you. I call them up on the phone. I'm not even going to put it in writing because it would sound awfully mean and just say, I think there might have been a little mistake here.
Right, but you're good about it, but I'm gonna tell you is that there are other attorneys out there on the other side who are not so nice, and I have received calls from other attorneys saying, I had this landlord-tenant case, I didn't comply with Fair Debt Collections, and now they're threatening to sue me, and I have to put my malpractice carrier notice. So it does happen. So you're nice, everyone in your office is great, but another attorney may not be so nice, so make sure you comply with the law.
Well, representing the tenant, right, this is something that you can use to try to help them get get some sort of settlement worked out, because no attorney wants to get sued. But also for my purposes, really, if we do have a question about the debt, of course I'm gonna ask for the landlord to, you know, come up with some sort of documentation of why they think my client owes what they actually owe, because no complaint's getting filed if they make that query until the landlord responds.
I seem to remember last time I read the Fair Debt Collection Practices Act that it applied to those in the
Collection business.
employ of collecting versus to the principals themselves, such as the landlord. Is that true? So in other words, the landlord doesn't have to, if the landlord is acting pro se, for example, doesn't have to worry about the Fair Debt Collection Practices Act, or does?
Well, it's the attorney that has to worry about the fair debt.
Right, but if there's no attorney, if the landlord is acting,
I would say if the landlord was a corporation, yes, you'd have to comply with fair debt and LLC. If they're just mom and pop landlord, Mr. and Mrs. Jones, I would say no.
If it was the Handies, oh my God, I would totally go after them.
how do you verify?
Cut that, edit that out. Edit that out.
How do you actually what's involved in quote-unquote verifying the debt? I mean, is it just...
It's either some clients will have a printout or a spreadsheet.
No,
or
just a statement, an account
any-
statement. Yeah.
Pretty much, yeah.
Got it.
Yeah.
One little twist on the debt validation, I think they could be oral now. I think there's a Second Circuit case that reads the act to say an oral request for debt verification is as valid as a written one. So I start to modify the notices to eliminate the request, any language about having to have a written. So it's another thing to look at, maybe oral request that can then.
But if you're advising your tenant, I always say writing, just to
Sure.
have it documented. Right?
So can I just ask for clarification? Because I don't really know anything about the statute. It doesn't come up very often, I think, because you deal with it before it comes to court.
Yes.
But if I'm understanding you right, you're saying this is something that happens, that is a requirement before the case is filed in court. Is that what you're saying?
On the notice of termination of tenancy, the attorney has to include that language because they're in the business of collecting a
So
debt.
once you're in court, you know, these people are volunteering, they come to the rent escrow hearing.
I'm still gonna use it.
They see the notice, it doesn't have that, then what are their remedies at that stage?
I'm going to do the same thing. I'm going to talk to the attorney on the other side and say, oh, oops, looks like you made a little mistake here. This is a violation. It's a violation of the attorney, right? It's statutory damages against the attorney, not the landlord. And so why don't we try to work something out? I'm also going to make the argument, and we'll talk about this after the break, that they failed to satisfy a necessary condition precedent in that their notice wasn't valid because it didn't have that FDCPA language in it, and I would try to get a 12B1. And I don't know what you would decide on that.
And I can't tell you. I can't, because that would be an advisory opinion.
Yes. But I've never had, once I flag this to my opposing counsel, that case is going away.
Oh, yeah.
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 So you've given them notice of termination, and you've got 60 days to file the complaint in court. You wait 55 days. Is it legal for the tenant then on the 56th day to say, I want an accountant, and if you don't give it to me, you can't file the eviction complaint against me?
They have 30 days to send the written request for the accounting.
And then the language says you can start even if you,
right.
Just because you get 30 days to submit a request for a query on how much you owe, it doesn't prevent the landlord from starting action within that time, so you're protected.
Okay.
But the landlord does have to respond
Right, you have to
before going ahead with the legal process. Someone else had a question? No? Okay.
Do you want to take a break or you want to do the next section?
How fast do you think you can haul
They're
through?
dying for cookies.
Haul through the Title 12.
Well, Title 12, action for possession, so Title 12, Chapter 169. So once the tenancy is terminated, now you have to actually start an eviction process. And as I mentioned earlier, it's either by filing or serving. If you serve, you've got 20 days to file your case. After that, if you file first, you've got 60 days to serve. It really depends on what your practice is or how you want to do it. And again, I do a lot of service first because I'm able to resolve a lot of cases before I actually have to file them. Or if I tend to have a client and the rent is huge, and then I'll file first and I'll get the escrow hearing and then serve the tenant after that. You have to file your summons and complaint. You file in the county where the rental property is. So I get this all the time. Joe landlord, I live in Rutland County and my property is in Newfane. The property's in Newfane, you go to where the property is. There's no dispute about that. With your summons and complaint, if anybody needs any forms, you can feel free to call me at any point. They're pretty standard, you just change different names and things like that.
Remember, they're representing the tenant.
Yes. Oh, sorry. Sorry. If you take some other cases, just call me. And then the law changed a few years ago. There's been a few tweaks. So if you haven't read the landlord-tenant laws in the last few years, you should really take a quick read. So now you're required, if there is a written rental agreement, you have to attach it to the complaint along with the termination notice. If you don't attach your lease, it is grounds for dismissal and it will get tossed. So make sure if your client says they can't find the lease, you don't start until you have that lease in your hot little hands. So, but you have to do that. And then if it's a non-payment case, you can file a payment of rent into court motion. The court will set it for a hearing. And if the tenant has already if you've already filed the case and the tenant files an answer, and then you file your motion for rent into court, the court will just mail them a copy since they're a party. But if you start by filing first, you're gonna have to serve the tenant with the hearing notice. One thing I wanted to say with the rent, I did find this out from Jack McCullough a few years ago when we were down in Montpelier. A rent escrow motion, here's your little high point of the day, is not just for non-payment of rent cases. So if you start a no-cause case, which more than likely your tenant is gonna stop paying the rent, you can file an escrow motion in a no-cause case, or a cause case, or any other case if you read that particular statute. I thought that was brilliant, and I went back and I read it, and sure enough, it does not specify non-payment cases only. So you can see a rent escrow motion at any time as long as rent is owed.
So you could be in here on any particular type of termination
Right.
in a rent escrow hearing.
Right.
10 days? 10 days?
The 10 days. So if there has to be at least 10 days, the court tries to set
10
these.
days notice of the hearing.
10
Or you
days.
can continue the hearing.
You need to speak up.
Speak up, David. Speak up.
Oh, sorry. 10 days notice. For a rent escrow hearing, you have to get 10 days notice of the hearing. So if you file and serve and the tenant gets it 8 days before the hearing, it's no good, you can continue the hearing, which is sometimes a real breather for a tenant who's financially troubled.
Right, but if you're here, so something.
Or if you're here, you can.
Well, if you're here, I just want to say that if you have, when you send out notices for service, you really need to put in the cover letter, it's got to be served before X date, because sometimes the sheriff doesn't get it in time, and then you're too short, you're within the 10 days. But if you're here helping the tenants, you're going to have to come back to court at some point. It's going to be rescheduled. So sometimes, I just had a case like that. Service came in late. The tenants came in. They got a piece of paper from David's office that asked for the hearing to be continued because there wasn't the 10 days. And I said, let's have a chat. You're going to have to come back here anyways. I will do an escrow order that basically works in enough time that gives you plenty of time. Because if I have to come back here and you have to get served again, it just keeps costing you more money. So I try to be fair if that does come up.
Well, everything is a, basis for a little leverage in the bargain.
Yes, it is a lot of leverage, but if the tenants know that, so if you see that they haven't been served within 10 days and you know they have no money whatsoever, and there's no way they'd ever be able to pay an escrow, you can ask that the hearing be rescheduled, and that would buy them some more time. Thank you, David. That's a nice little tidbit for the tenants. Yes.
I'm saving the rest.
You're saving? Oh, geez. And then the different judges are different as far as the
Everything.
Yes, everything. So if you get to the escrow hearing, you should know how the judge in the county that you're going to likes to handle these things. So, for example, when Judge Pearson was here last term, if they got served on, say, January 7th, a lot of judges will let you prorate, from when the case started. So escrow hearings.
From the date of service.
Right.
Yeah.
So they're all different, it gets a little confusing. So with escrow hearings, you can start the escrow order from the time that the case was filed, commenced, forward. So you look at that clock, but sometimes it takes a little while for the hearing to be scheduled. And so Judge Pearson, he would do, if the filing date was, say, January 7th, he would not let you prorate the rest of January. He would not let you start until February 1.
Interesting.
With your escrow, yeah. And then Judge Tour, if you file the case first and you get your hearing, she will start your clock at the date the motion for rent escrow was filed, right? So you just need to know what different judge, everybody's a little bit different about how they calculate your time. Some prorate from the time, but read the statute, it's in Title 12 on the rent escrow motion because it's full of information. And it could be a partial payment. I tend to find if tenants have habitability issues, the heat's not working, things like that, you can have a full-blown hearing on that. Some judges will take the opinion that, you know what, I'm just gonna have you pay all your rent into court and we'll hash it out later. If you tenant are entitled to some money back later, then you'll get the money, but otherwise I just want all the rent coming in. Some judges will do, I think the value of this apartment right now and the condition it's in is about 50% of the value of the rent, and you're only gonna pay half into court. So every judge is different, so you really need to, just be aware of that. Just because the statute says one thing, the court may do something else.
And we'll talk more about that later. I've had many cases where tenant has paid zero while the conditions were bad and had fun 3-hour rent into court hearings. Anyway, so just wrapping up this section of the basic law, the reason why this rent into court hearing is so important is because if the tenant fails to timely pay whatever is ordered in the rent escrow order, the landlord the next day is getting a 5-day writ to get them out, and chances are very good that that tenant's going to end up being homeless because good luck finding a place in Chittenden County within 5 days. So this is a huge issue for tenants, and that's why it's so important that you guys are helping them out, because late payment is not acceptable. Next day, if they miss that payment, the landlord's going to be going for a 5-day writ, and they'll be homeless. So we'll talk more about what you can do to prevent that after the break.
Great.
So one of the things we want to make easy for people is to get in and out, get out of the clinic situation. When you're talking to somebody, you have a choice. I mean, you can give them pro se advice. They can go in on their own, or you can enter a limited appearance, and we will have the forms for that. You can enter a limited appearance just to appear at that hearing only, and then appear in front of the judge on the issues around the payment rent into court. We also will have a form for withdrawing, because in this court, because of the system they have, it's important that you file a motion to withdraw. So both those will be available, and it will be easy to do that. So, and there will be people here to help you out with it as well.
Thanks, Tom. So the first thing that I want to talk about is getting the case dismissed. So like I was saying before the break, renting into
Rarely
court.
happens, rarely.
So like I was saying before, renting to court is a very dangerous thing. I never want my client to have a rent escrow order. Why? Because something goes wrong, they overspent on Christmas presents, what have you, they don't have the money on the day that it's due, and the next day, Nadine or one of her fellow landlord attorneys will be going into court and asking for that 5-day writ. And 5 days, no one's gonna have a place to go by then. So I try to get rid of that case just as fast as I possibly can. Different people have different strategies.
Can we, 1 second? So we talk about the 5 days. So when you come in and talk with the tenants and the rent escrow order is issued, and if there's a legitimate reason that the escrow order is going to issue, what you need to explain to the tenants, and what I try to explain to them, and Judge Tour also explains the order as well, is that we talk about a 5-day writ, but it's not really 5 days. It's the tenant has a due date that they have to pay their rent to court. The tenant, you call the next working day. If the payment's not there, then landlord attorney sends paperwork up to the court to get the writ. The paperwork goes to the judge. When the judge signs it, comes back to you, then you send it out to the sheriff for service. Once it's served, then it's 5 working days. So what I usually tell tenants is and there are times when they know they are just not going to be able to make the payment into court, and they are afraid that they are literally going to be out on the street the next day if they don't make it. I tell them, if you don't make the payment into court, you have, I would say, at least 2 weeks at a minimum before you'd have to pack it up and be out of there. So that makes a lot of them feel a lot better, knowing that it's not the next day, that they have a few weeks. So that's generally how it works. And I'm just going to put in a quick plug for mobile homes. It's a 30-day writ for a mobile home. Apartments, everything else is five days on the writ. So if you see a mobile home, you want to make sure, if you have a tenant that owns, and when I mean mobile home, I mean owns their mobile home and pays lot rent in a park that they do not own. It's a 30-day writ, so you want to make sure if you get an escrow order for that type of tenant, it's 30 and not 5, because that's a huge difference.
Or if they rent from the mobile home lot, rent the mobile home in the lot, in the park, run the hour.
No, it's 5. It's 5,
No,
yeah.
it's
So
only
if
5
they,
that applies. Okay.
if they rent the mobile home from the person who owns the mobile home, it's a typical landlord tenant, it's a 5-day writ. The 30-day is only for if they own their own mobile homes.
Nadine's nicer than me. I prefer to scare the bejesus out of my clients a little bit and just emphasize you must pay this on time.
You got time.
But I want to just clarify one thing, because we haven't really talked about this. The way that these motions for the writ of possession work is unlike normal motions. We do not wait for a response.
Correct.
And the reason is, they are paying to the court. We know they didn't pay. We're not relying on, what the landlord's saying. We're relying on our own records. And so those get issued, as quickly as we get them processed and I get time to look at the file, is how quickly they get signed. We don't have a hearing, we don't wait for a response, and that's important to know.
Right, thank you.
How many bank accounts does the court have with
How
these
many
rental?
bank accounts?
Well, is every?
It all goes into one place.
It all goes into.
There is a rent escrow account.
Okay.
Yeah.
And the court does have I know Judge Teachout worked on it a few years ago, but a standard rent escrow order form that explains where you make the payment, how the payments are made. It's always bank check, money order, or cash payable to the court. If it's a money order, the court doesn't take personal checks. And you have to explain that to the tenant, because I think sometimes Donna might be able to tell you is they show up and the money order's made out to the landlord or or they bring a personal check in and they don't understand. And some of these tenants really do not understand the difference between a personal check, a money order, or a cashier bank check. So don't take anything for granted. You have to explain that. But I have my own bank account, but you explain
And
it.
not just the tenants, but a lot of social agencies. Housing Resource, not so much, but DCF, if they're making what are called vendor payments on behalf of a tenant to a landlord, will very often just ignore a rent escrow order and continue paying the landlord. Or Vermont Veterans Services is another one who has a little issue with realizing that a rent escrow order is a court order requiring the payments to be made to the court. And so those issues sort of arise sometimes. You have a tenant come in with a writ of possession who's actually made all the rent escrow payments but made them directly to the landlord.
But ideally,
You have to, get verification and move in the court basically to set aside the writ.
But ideally, you're never going to have to make those payments into court because we want to get the case dismissed. So let's talk about all the ways that you can get the
Love how
case
she
dismissed.
brings it back around. Okay.
Okay, so the first thing that I look at in a case is, can I just get rid of this thing nice and quickly? Another thing to keep in mind too is that when you're filing a motion to dismiss, you don't have to file your answer until 10 days after a decision is made on it or until the judge decides to postpone the decision until the merits. So I think, and this is just a theory, that no rent escrow order should be issued until the court decides on my motion to dismiss. This is untested. So I'm just putting...
I agree with you, actually.
Okay.
I do agree.
I love it. Thank you. So now we've heard from Judge Tour. no rent escrow until the court issues an order on the motion. So that's always going to be the first thing I'm going to try to do. I recently had a case in Franklin County that I got pretty last minute, and so it wasn't until the actual day of the rent escrow hearing that I was able to turn in my motion to dismiss, having met with my client the day before that, and Judge Rainville did dismiss the case on the spot.
I'd like to say that you do have to have a legitimate basis for filing
Of
your
course.
motion to dismiss.
Of
Okay.
course.
Okay.
So the things that, yeah.
Just a procedural question. If we're coming in the day of and meeting with our clients during the 3-hour period, will we be filing oral motions to dismiss, or will we be expected to keep the case and file a motion the day after?
You're not expected to keep it. That's one of the forms that will be here that Lawline will have their standard sort of, with blanks. So if you want to file it there, right at that, in court, you will be able to do that. If you feel like there's an issue there, but you really aren't in a position to file it, one thing you could do is say, Judge, we want to file a motion to dismiss, we need to investigate something. You could argue to, delay the rent escrow hearing or put the payment out a little further so the motion can be resolved before the payment's due, whatever seems appropriate.
And I think the danger is there's a case, Trillium Holdings LLC v. Buchanan, which was a decision by Judge Teachout in 2013. Tenants' acceptance of a rent escrow order voided their valid argument that could have been made on a motion to dismiss. So I would never want to step to a rent escrow order if I thought that there was a chance that my client could get the case dismissed.
Although I think there is, I've never had this issue come up, so I can't tell you how I would rule, but just listening to that, since the law actually gives tenants 10 days after the rent escrow hearing to file an answer, and because motions to dismiss can be filed on the date, that's either an answer or a motion to dismiss is due at that time, I'm not sure I would agree that you waive anything, since you really had until 10 days later to file that motion. So I don't know, I'd have to consider it, but I think there's an argument certainly the other way.
All judges are different, right? But I would definitely try to go for a motion to dismiss before stepping to a rent escrow order. So what am I going to be looking for? The first thing that I'm going to look at is problems with the notice to quit, which is why Nadine explained to us what they are supposed to look like. Often they don't. So I'm going to look for inadequate time, using those bases that Nadine outlined for us. I'm going to look for an improperly delivered notice to quit. For instance, in that Trillium case that I just talked about, the landlord used their key to the tenant's apartment to come in and leave the notice on the kitchen table. This does not fly, right? That is not proper delivery of the notice to quit. It's also trespass. And so if it was delivered some other way, Rachel, my colleague, was just telling me she had a case where the landlord sent the notice to quit via email. This is not proper delivery.
Yes, and they think, a lot of landlords think it's valid. Email, not valid in Vermont.
Nope.
Not yet.
Not yet.
Not yet. Someday maybe. Someday maybe.
Judge Mello is sort of of that opinion.
We're going over what we think that the law is. So, yeah.
Just let you know what one judge says.
Another thing that I'm going to look for is failure to notify the tenant that they have the opportunity to redeem in a non-payment case. And in those non-payment cases, another thing I will look for is, did the landlord include something other than rent as rent in that language about redeeming? So for instance, the landlord may have included their $2,000 bed bug extermination charge as the amount due for the tenant to redeem. No, this is
in the sample notice I gave you, it says in bold, rent only, really, because legal aid, my worthy adversaries, have, I think you've won, I won my late, a client put a $15 late fee in the notice. Does that kill the notice or not. I had Judge Mello, and he did not dismiss it. I love Judge Mello. He did not dismiss it, but I tell all my clients.
I would have appealed that.
For $15. I know, but we worked it out, more than I worked it out. So if you put anything other than rent, it's grounds for dismissal. The statute is clear, it's rent only. So some clients get a little late fees, damage charges, things like that, but they owe me money. They owe me an unpaid security deposit. It's gotta be rent only.
But if the lease defines rent as all this stuff as additional rent, the statute...
It's not additional rent, it's a damages charge, it's a security deposit.
Or other charges.
What about utilities? Doesn't the statute define rent as including utilities, or can it include utilities?
If the lease says that the rent includes utilities, then, that would be rent. But if it's just an issue of, say, the landlord had to put the utilities into their name because the tenant didn't do it, then the landlord should be evicting them for a substantial violation of the lease, not for non-payment of rent. And I would get that case dismissed if they tried to call it rent.
Yeah, I mean,
I shouldn't say I would get it. I would submit a motion.
I would try. I would try.
Case dismissed.
Yeah, I mean, rent is defined in 4451 subsection 7 as rent means all consideration to be made to or for the benefit of the landlord under the rental agreement, not including security deposits. So is a late fee rent? I think there's a case from, I think it's Judge Wesley. I think that's the one that you all rely upon.
Well, there's also Bennington Housing Authority v. Lake, which went to the Supreme Court, which was very clear.
So, I mean, you try to avoid these types of issues. So just make it easy, just look for rent. But if you're representing the tenant, you need, and that's why you get the accounting is, what is this number comprised of? Is it all rent? Is it something else? And if it's something else, that should be a red flag for you.
The thing I've always been wondering about is interest. You occasionally meet landlords who tack interest on late rent.
No way.
Interest?
Yeah.
Believe
it or
motion to
not.
dismiss.
I see them, I've seen that done, I've motioned to dismiss and both won and lost on that.
I would encourage you to do a motion to dismiss if you saw such a thing.
Right.
Another thing I'm going to look for if it's a for-cause case is that the cause is not sufficiently specific. They actually have to tell the tenant what it was that they did that was just so wrong. They can't just say, you violated section 13 of your lease. This will not, in my opinion, cut it, and that's, I would cite to Andrews v. Dunbar for the proposition that they do have to be specific as to what the violation was, because how can the tenant possibly defend themselves against such an accusation if they don't know what it is that they're being accused of?
And it doesn't have to be so specific. So you don't need to cite every time there was a noise complaint. Oh gosh, I see those, I go nuts. You want it to be short enough. You don't need a 5-page notice to vacate. You need to cite the provisions of the lease or the law, Vermont law. I think it's 4454. Has A and B, C and D. I think that talks about violating health safety codes, damaging the property, or quiet enjoyment. So you do have provisions under state law that protect you, as well as the lease. But it's, you cite the provisions of the lease. If the landlord hasn't cited, the landlord can only rely upon the provisions of the lease that are cited in the notice. You can't, the landlord can't come back 6 months later and say, oh yeah, I forgot to mention these 5 other sections I should have mentioned. So you have to make sure everything is listed and that there's some indication of what's been going on. Again, it doesn't need to be a blow-by-blow of every single thing to withstand a motion to dismiss or whatever motion's filed.
I have seen ones where it said things along the lines of, your son is a goof, and so that was the basis for that. This one.
Not my notice, I'm telling you.
Definitely not. Like I mentioned before, when we were talking about the Federal Debt Collection Practices Act, I see that language being on the notice as a condition precedent that you want to see before the case gets filed. So I would, and this is untested, right? So I would give it a go under a 12B1. And for cases, again, which you probably won't have, in which the tenant has a Section 8 voucher, which is a form of rental assistance from your local housing authority, if the landlord fails to send the notice of termination to the housing authority, in addition to the tenant, and so many of them don't do this, then that's also failure to satisfy a condition precedent, and I would try to get that case dismissed on a 12B1 see Parsons v. Norway, and Parsons v. Norway wasn't clear on why it was getting dismissed, but then I had a case in Franklin County where it was dismissed as a 12B1 for that basis. Yes, that's 20-2-14 LECV. And I know Judge Rainville also recently did it again on another attorney's case as a 12B1. Okay, so those are my problems with the notice to quit that I see most commonly. And that's the first thing that I'm always going to look for. And if there was no notice to quit attached to the complaint, again, that's going to be a basis for putting forward a motion to have the case dismissed.
So you ready for Chris Curtis, who's with Legal Aid, filed a motion to dismiss in a case, a subsidized housing case that I have. And in his motion, part of it, which my response isn't due till next week, he said, I think one of his arguments was, I didn't attach the whole lease. So this is a rural development lease, and it's about 50 pages long. So I don't give the whole 50 pages. I give the crux, the basic, without all the addendum. So I'll let you know. If you come back for another one of these, I'll let you know whether I survive my motion to dismiss on that argument, which I thought was an interesting argument.
Yes.
So we'll see how that one goes.
You get to be really creative when you're doing landlord-tenant law. It's a lot of fun. Okay. So next thing that I'm going to look for is, does this plaintiff actually have standing to sue at all, or can I file a motion to dismiss under 12B1? So what I've seen is that a landlord is filing an eviction case, and they no longer actually own the property. The property was already foreclosed on, and so my tenant's confusion came about because there was a notice stuck on his door saying Bank of America owns this place now, and the landlord's still demanding payment. So that's a case that you can get dismissed.
But you should ask. That should be another thing you should ask. Is this property under foreclosure? That is huge right now, and tenants do have a right under. Oh gosh, what is it?
Protecting Tenants Foreclosure Act.
Protecting
It's
tenants.
sunsetted last month.
Oh, it did?
Oh, that's right.
All right,
It's over.
forget that law.
Forget that law.
Forget that law. But tenants, even under Vermont law, do have rights under foreclosure cases, so, but that would be an interesting, that you should know.
I actually had an interesting case, though, that was just recent. The bank foreclosed. As you probably know, once the bank forecloses, it simply will get a writ from the court and put the tenant out. This bank had its attorney send a notice terminating the tenant's tenancy before trying to get the writ and get the tenant out, and they did the notice wrong. So when they went to get the writ, I filed a motion to stay the writ, and then they filed an eviction case, and then I filed a motion to dismiss the case for this tenant without lease who had lived in the house for 12 years, saying, no, go back. Let's give us a 3-month notice, and then you can go to court. So the guy got, I don't know, a lot of months. It was sort of a bizarre case, but.
David's really great with the bizarre cases, I gotta tell you. Whenever I get something really wonky, I go to David's office. What do you think? Anyway, another thing that I saw once, and it was very exciting to me because I got to use one of those wonky things that we learned in property law that you thought was totally useless at the time. It was a remainderman on a life estate trying to evict the tenant, but they didn't have current possessory interest. So that case dismissed. It was great. Okay, another thing that I'm going to look for is, and this is why it's great to have that lease attached, is the eviction actually contrary to lease terms, such that I can put in a motion to dismiss under 12B6, yes?
When you meet with the tenant, make sure that they're in the unit that they're being evicted from.
I'm getting there.
Oh, you have that?
Yes, I have that.
I will tell my story then. Oh my God, my client transferred somebody without telling me. Can you believe that? Yeah.
So, eviction contrary to lease terms, a no-cause eviction can't be filed during the period of the written lease. I recently had a case like that, and oh my God, I kept my person in that apartment for so many months. It was insane. The landlord was very, very unhappy.
She seems nice, but she's not that good.
You can't evict someone for no cause. Anyway.
I know.
Another one that I've actually seen is that the cause alleged in a for-cause case is actually permitted under the lease. If they don't say that there's no smoking, then you can't evict them for smoking in the apartment. Done. And lastly, I'm going to look for a no claim and so that I can file a motion to dismiss under 12b-6. For instance, I did have one with the wrong property address. The landlord was trying to evict my client from his own home. So he just goofed, right? He listed his own address because, you know, the sheriff can't. So look to make sure that the address is correct, and it's got to be specific, right? Because the sheriff needs to know where to deliver this writ. And so if there's no apartment number, if there's something missing, then I'm going to try to have that case dismissed. And of course, you've got those cases where the rent has actually been paid, and it was solely a non-payment case. And that's kind of like a motion for summary judgment with proof of payment, but you can, you know, do a 12b-6 with, you know, summary judgment as your alternative. Anyway, so those are the things that I'm going to look for. There might be other things that come to your attention that are potentials for motion to dismiss. These are just the things that I most commonly see. And you'd be surprised how many of these cases you can actually get kicked.
Should have a landlord doing their own notices.
Oh my God,
They should be
yes.
going over it with a fine-tooth comb.
Yes. And so that's what I'm going to look for first. And I prefer not to save this until later. Some folks might, you know, let things drag on and then file their motion to dismiss. But I don't want to have a rent escrow order issued. And also, if you get the case dismissed early on, whatever the, you know, if it's a non-payment case, the rent's still, they're just going to refile, right? But instead, why don't we go into one of the rooms out in the hall and have a chat, right? To see how can we resolve this so that the case doesn't have to be refiled and try to actually come up with a solution. And that is what we do in, I think, almost all of our cases. Yeah.
We try.
We try really hard. So, yeah, that brings me to the next. Any questions on getting a dismissal? No? Okay, great. So that brings me to the next issue, which is negotiating a settlement outside of the rent escrow hearing. So it's been my experience that if the attorneys are trying to work something out before the hearing, even if your hearing was scheduled for 9 o'clock, the judge will allow you some extra time to try to sort things out amongst yourselves.
And especially during this clinic, we're expecting a lot of leeway for that.
So this is where talking to your client is going to be, you know, really important. What do they actually want? Sometimes tenants just want to get out. They hate their landlord. They think he's a jerk, or you know, they think the place is a dump, and they just want to go. Other times, your tenant wants to stay, and so your strategy is going to be different depending upon what the tenant actually wants to do. So if I'm working with someone who definitely wants to go, and they know when they can go, then it's in our best interest to just try to negotiate a settlement, not have a rent into court order. We're going to be looking for a very specific date and time to leave. I actually put in the time of day that they're expected to be gone, just so there's nothing left to chance.
So I'm circulating 2 agreements.
Yep.
These were both filed, these are public, so I didn't take the time to get rid of any names because I didn't have any time. But one is the Winooski Housing Authority versus Abdi Tahir. This was an agreement with a move date. So Jessica was just talking about a type of agreement that you would use. This is the form that I use, and depending on, with counsel with the other side, we tweak. These are generally what they look at. There might be a provision in there about a neutral reference, things like that. It's what you come to an agreement with. What are you going to do with the rent? Is there going to be a judgment for the rent? Is the landlord going to waive the rent?
Yes.
And then what's your move date? These court agreements give everybody a lot of peace of mind because a stipulation of possession is you as a landlord are going to get your writ of possession, and you tenant know when you have to be out, because if you're not out by that date, the sheriff is coming the next day. So it is a full settlement. Everyone can sleep at night. Well, the tenant's not sleeping at night, but the landlord knows that the tenant is going to be out by a date certain, and you just negotiate what your move date is going to be.
The tenant's going to sleep at night because I never want to do one of these agreements unless my person has a place to go. And so I'm going to be looking for, like I said, specific day that they're going to be leaving, knowing that they have another place to go. waiver of arrearage because the landlord is going to be saving so much money, not having to have this thing dragged out and paying Nadine to write a bunch of motions.
I think most landlords agree to that. They just, if they want the tenant out, they just want the tenant out. I tell my clients, you're never gonna see the money. I think, I rarely get to do trustee process. Just the tenants I work with, they're under eviction for a reason. They've lost their job, they're not well, something. So you're never gonna, almost always never gonna see the money. So if you can at least get possession back, which I tell my clients is number one, if you want possession, then let's get possession back. Then you can work out some sort of agreement. If you do these sorts of settlement agreements in the public housing or the Section 8 world, if you have a tenant that has a portable voucher, this is not, right, but sometimes you don't get them all. I mean, especially if I come in here and you're getting help now in the rent escrow days, I have a lot of Section 8 tenants that are here that are unrepresented. So if you work out some sort of agreement with the landlord, and it's an agreement, not an eviction. I consider this, and I tell Section 8 that they agreed to move on their own, that they were not evicted. If I tell them, if we can't work it out and you make me go out there and we have a trial and I win and you get evicted, then you are evicted because I'm going to ask for everything, all the rent, the court costs, the attorney's fees, and then you will lose your Section 8 because that is a violation. Well, then you can fight to keep it for them, but they are jeopardizing their voucher because they're not in compliance with the program rules. So what I tell tenants, if we come to an agreement, then you leave in good standing as long as you do what you say you're going to do under the agreement. And if a tenant leaves in good standing, which is usually you leave owing no money and you don't trash the place on the way out, then more than likely you get to keep your voucher. So
and if there's a waiver of arrearage, you have left owing no money.
Right, and you work it out that way, and that's. We do a lot of agreements like this, and that's why you get to an end resolution, and it gets it out of the court, the tenant knows what they have to do.
But I will add, not all landlords' attorneys are as easy to work with as this one. And there are some who never are easy to negotiate with, at least when I make suggestions, with an unrepresented tenant. And I say, well, what about, would you consider an agreement? And they'll say, no, we want our money, even though they're never going to get the money. So you may have a harder sell with some of these people than what you're hearing today. Just a warning.
But if you are doing one of these agreements, you definitely want to negotiate in references. Around here now, it is so hard to get an apartment. So hard, especially because a lot of our tenants are also not going to have the best of credit. If you've got a bad landlord reference, no one is going to want to rent to you. You are done. So I always am going to negotiate in that reference. We usually put in a provision about abandoned property. Under Vermont law, the landlord has to store abandoned property and then build a tenant. This is all right.
Not anymore.
All right, so this is what you need to tell them this too, okay? Because there's so much to tell the tenants.
But when we do these agreements, I usually just say in there, and this is what we've been doing lately, anything that is left behind is garbage, and they can just get rid of it. Because generally that's what it is. It's just something that the tenant didn't want anymore, and so why make a mess of things? Let's just have it be done. And we also want to make really clear what the disposition of the security deposit is going to be when the tenant moves out. Let's see, keep taking. Say the client doesn't have a date certain that they can move. They don't have another apartment lined up. They have all these places that they're going to look at, and they're so sure, no. Chances are good, even if they have 5 appointments to go see an apartment, that does not mean one of them is going to come through. So coming to an agreement in a case like that is so risky. If your client doesn't have housing on the move-out date, if you do one of these settlement agreements, like Nadine said, it gives the landlord a lot of peace of mind because they've got their writ in hand. We know exactly when that tenant is getting out, right? But for your client, if they do not have a place to go on that day, then they really have no place to go. Right now, the position of the Department of Children and Families is that if someone made a move-out agreement with their landlord to avoid eviction, they chose to become homeless. And so they don't qualify for emergency shelter. What? And they are literally, we should work on this together to get them to change that policy.
I used to always tell them, go over there, they'll give you a hotel voucher. And
they will not give you a hotel voucher. They will say, you chose to be homeless, You should have gone the whole way through the eviction process. It's not until you actually have the sheriff coming to your door with your kids crying and, you know, dragging you out of there that you actually became homeless without doing it to yourself. So, I mean, I think it's a real issue, and I think we should work on it together to try to get the department to change their position on that, because it really puts a big dent in being able to come up with agreements when someone knows that if they don't get an apartment in time, they will literally be on the street or in their car.
You talked earlier about a 5-day writ of possession in the rent and escrow context. If we're doing one of these agreements that just say writ of possession, is that, you know, immediate, the sheriff just kind of stands there while you move out?
So when we do one of these agreements, then we're setting, you know, off in the future the very specific date and time of here's exactly when the sheriff is going to come. It's usually the case that the tenant will accept service of the writ on the spot when we're doing this. And that way, there are no questions. Nothing is left to chance. And again, I don't like doing this unless my person has a place to go and we know it, because I can't have one of my clients sleeping out on the street.
But I think his question is, are you negotiating agreements that have 5 days after the sheriff shows up, or that moment they're going to put their stuff on the street?
What I usually do is if they're getting, say, 60 days, I'll have the writ issue at like 30 days in the agreement. I get the writ. I always serve I just always serve the writ. That way there's no question. If we come to court and we work out a deal or some sort of agreement or judgment's entered or something, the sheriff in this county will take an acceptance of service. You don't actually have to have the sheriff serve the writ to be enforced. The sheriff will accept an acceptance of service form. So
the writ is saying today,
right.
The sheriff is going to show up at X time on X day and take your stuff out of your house.
Right, it's very specific, and the sheriff is fine with that.
There's no grace period. Get yourself out within 5 days, get yourself out right now.
Here's your deadline, noon on whatever date, and that's when you have to be out.
And so when I'm making this agreement of my person...
Because you're serving the writ prior to the deadline.
So you've got, it's, when you get a judgment or you have some sort of agreement like this, it's under the statute, it's a 10-day writ. So I always make sure that I have plenty of time before the end date that service is made. So, and your writs are good for 60 days. They expire after 60 days. And you can get, there are alias writs of possession. If your writ's going to expire and the sheriff isn't going to make it there before it expires, you can request an alias writ from the court. But I always have enough time in between that it's never a problem. But you have to be careful about the timing. Is the writ stayed? Is the 60-day clock ticking? So when you want it issued.
You have to be careful about the writ if your person doesn't have a place to live, because even if you thought you gave them a lot of time to find other housing, chances are pretty decent that they won't have a place if they didn't have one lined up. And so this can be really risky if your client doesn't have another place to go. We actually had a case together where my guy got something like $5,000, I don't even remember. It was like a decent amount of money, and he still didn't find a place in time.
But then what you have to understand too is if you can't make a deal, then the other part is I ask for a merits hearing, we get in here, we have the final hearing, assuming I win, I get my judgment and my writ. They get served, they have 10 working days after that to be out. So you have to weigh, can I buy them some more time, what can I do? Or do they risk it? And I don't know what the defenses are, if there are defenses. Some tenants think that and this is why I think it's really important that you're here to help them, is because the tenants think they might have a viable defense, but they really don't. So and I'm going to give you a specific case. 2 weeks ago, I was up in front of Judge Rainville in St. Albans. It was a no-cause case. I had a situation where 2 units, the tenants were not getting along. They hated each other. They posted on Facebook. They would call the cops. It was animosity between the tenants. The landlord is like, I can't take these calls all the time. Somebody's got to go. I have to break up this situation. There were no claims against the landlord per se. We sent the no cause, the tenant calls me up. I even get a call from a lawyer who didn't think I gave enough notice, and I gave enough notice, and he didn't represent this tenant, and she gets to court, and she heard, you can't evict me, he's retaliating against me. So there's the retaliation defenses, and the discrimination defenses, and habitability defenses, and I think Jessica's going to talk about some defenses in a bit, but she thought she had this great retaliation defense. And I'm like, I had her in the meeting room, conference room outside, and she brought her little boy because they're out on, and this is what it's like, okay? They bring their kids to court. It's hard. It's hard. So you're in the room, and this was the 23rd. This is 2 days before Christmas. I get scheduled for an eviction trial. So I had a very nice landlord. I said, just let me make the deal. Let me give her till the end of January, waive any court costs, waive any attorney's fees. Let's just get her out of there. Let's get her through the holidays. He's like, fine, make the deal. I went into her, I said, this is what he's willing to do. She's like, no way, I want to see the judge. I have a valid claim. I knew she didn't have a valid claim. And she's like, you're his lawyer. So if you're there to help, if you can give them insight on whether they have a valid defense or not, because I knew she didn't have a valid defense, she would have taken the deal. And she's like, I don't have a lawyer here. I want a continuance. I want to go get a lawyer. I'm like, you've had 3 or 4 months to get a lawyer. The judge is never going to grant that. So sure enough, we go out there, put the case on, and Judge Rainville's like, you have no defense. So she's out on the 12th. She's out with her family. She has nowhere to go, and she has a voucher, which, oh no, you know? So, I mean, this is why I think it's really important, at least if they can get some advice of whether they know whether they have a valid defense or not. Because I can't say I'm a landlord's lawyer. So, but this is what it's like, and I think that's why I think it's great that we have a clinic like this. So at least you can give them some advice so they know whether they have a claim or not, because she clearly thought she was right. And it just breaks your heart because now she's going to be out next week, and but this is real life. So this is what you encounter. So
I would have taken that case if only she had called. Anyway, yeah.
I would like to say, so as a landlord's attorney, when I send out letters, in all my letters to my tenants, I put in, you can contact Vermont Legal Aid, you can contact Lawline. I give them all the agency phone numbers. I know not all landlord attorneys do this, because when I get to court, I want to make sure that we're both on fair playing field, that I'm not taking undue advantage. So go talk to Legal Aid, go talk to David or Tom or somebody, and get some advice and see if we can work it out or not. So at least that's my school of thought on how these cases go.
And just to be clear, right, if my person has no defenses at all, and I know that they're going to be out in 2 seconds flat because they don't have money to pay rent and escrow, then even if they don't have a place to go, chances are very good I will make a deal. But try to get them as much time as is humanly possible, because it is so hard.
That's what they're looking for. Legal Aid's looking for time, and if you've got a client that can give a little bit of time in the long run, it really depends on the landlord. I'll preface that, but it really depends on the landlord.
Jessica, can you just say one more thing about the letters that you were talking about? Because I'm not sure people really know quite what you're going to be able to get from a landlord in a situation like that, or a letter to a new landlord.
Oh, reference?
Yeah, what are you going to say in a letter like that?
So what we're usually looking for in the reference, and you want it to be really clear what it is that they're going to be saying. Person lived here between X date and Y date.
I write them up.
Yeah. They're leaving owing no money.
They kept the apartment clean. They never caused any noise problems.
Correct.
Usually you can find some gleam
Yes.
of good. It's rare that there's absolutely nothing good you can say, but usually you can find something positive.
Yep.
So especially if you make the deal that the rent is waived, then they do leave owing no money. If they kept a good apartment, there were no housekeeping issues, no damage issues, then those are positive things that you can put in the reference.
Yep. And sometimes, I don't think I've done this with you, sometimes we know that the landlord, if they get a call, is going to have a really hard time biting their tongue. And so in the letter, the reference letter, it'll just say, I don't give references over the phone. I only give written references. My apologies if this is an inconvenience for you.
And prospective landlords should respect that, because I tell my clients you never give a verbal, ever. You get either a written form or you have your preset reference for this particular tenant, and that's what you give out.
They have such a hard time biting their tongues.
That's why you don't do the verbal.
Yep.
That's why you don't do the verbal.
Now, say your client wants to stay in their apartment. They don't want to move. They aren't sick of their landlord. And it's a non-payment case, and you have no defenses to the non-payment. what I'm gonna try to do, again, out of the hall, in one of those little rooms, is to work out a repayment agreement with the landlord's attorney, and not have a rent escrow order, because I really don't like having those. And I think
No,
Nadine,
she's so
you have some-
averse to those.
I am.
So
You have some samples, right?
So the second, yeah,
How frequently do these rent payback agreements actually work out? My concern is that, you know, if the tenant can't pay the rent, how's the tenant gonna pay the rent plus $625 a
Right.
month?
Oh goodness, if it was 625 a month, we'd have big problems. But the way it's usually gonna work is if the person, say, like a lot of times I'll have someone who might be developmentally disabled, they're getting Social Security, and they really just can't manage their money on their own, and they know it, and they know they need help. And if we set them up with a rep payee so that someone else is managing it, it will happen. And we just have to make sure that that repayment agreement is going to be affordable, and then it's sort of taken out of their hands. But in a lot of my cases, actually, we're just going to do a full pay, you know, just by scrounging around for every single resource that is out there. You know, like we were talking, I had a case where my client owed over $6,000, and we got that money because she hustled.
it's amazing what they can come up with
Yes.
when they have to, really. And so there's two different types of repayment agreements you can do. The one that I handed out it's the Winchester Place Associates. It's the one that you do a court-ordered repayment agreement where the rent plus X amount is paid. And I think this one was, I think I gave them maybe six months or 12 months. Usually it's the courts, you have to ask the presiding judge what they would accept. Will you accept a 6-month court-order repayment agreement, 12 months? They usually don't go past the 12 months. Some judges, I think it's, I know it's just Judge Wesley, and I've got it at the office, do not do any sort of court repayment agreements with monthly payments that are made to the landlord. So this protects the landlord in that if you don't make the payments that you're supposed to, the landlord's going to move for a writ of possession. You're going to get the writ of possession. There might be a hearing, but if the payments aren't made, you're eventually going to get a writ.
This isn't the type of agreement that I want. I don't want it in court.
And then you only make it was a good point earlier, I only make repayment agreements if the tenant has the ability to pay. So if they have no job and they have no ability, there is no agreement. I won't even set tenants up because they will tell you whatever you want to hear. I swear, Nadine, I can pay my rent plus $500 a month. Okay, let me do the math. What do you have for income? It's just, I can't do it. You can't do it. You're going to fail in month one. And they think they're buying themselves time, and it's hard. But if they don't have the ability to pay, then you don't do repayment agreements. So the second part of that is a repayment agreement or a court order or court judgment that says you owe X amount of dollars and you have until X date to pay. And there is a provision in the statute, I think it's 12 VSA 47736, something like that. If a tenant at any point after a judgment's issued can pay all the money that's owed into the court, and that will stop the case. I always tell the tenants, I'll take it, and if you pay everything, you get to stay. And that's what the law is on a non-payment case.
That's after the judgment and before the writ is
Executed, right.
So it's a short window, which we haven't clarified, but at the rent escrow hearing, if you fail on the payments, it's a 5-day writ of possession. At the end of the case, when a judgment is issued, it's a 10-day writ of possession. But that's the window basically that they have to come up with all the money.
Right, I'll come in here for a final hearing, and the judgment will issue, and the tenant and I will work out a deadline date, which is longer than the 10 working days. Sometimes you can give them 30 days, you can give them 60 days, it's whatever. And I include the rent that's going to come due in the next couple of months. So you have until X date to pay X amount of dollars, and if you do, action over. If you don't, then the writ issues and you're going to be moving. So there are all sorts of ways that you can do these things. Eileen?
Jessica, one of my biggest concerns in doing this clinic and looking at representing tenants is that I'd be concerned that I wouldn't know enough about what would really affect someone's Section 8 or future eligibility for benefits negatively that we could put in an agreement. I mean, what should we be looking for to avoid
the thing you're trying to avoid is an eviction. And so that judgment that they were evicted is what is going to burn them in the
So
future.
just being ordered to pay rent into court isn't
Doesn't
really
matter.
effective.
No, right.
And making an agreement that says, we'll pay this or we'll do that on this date, none of that will affect them.
Right, it's waiting for the sheriff to come and kick you out after you lost a case that is gonna get people in trouble, which is, again, why the Department of Children and Families policy that you cannot get an emergency motel unless you waited for the sheriff to come and kick you out of your apartment is the only way to be.
And if you get a judgment against you, but then you pay up,
Right.
the landlord has to actually dismiss the case, so it's vacated essentially. So I'm assuming that means it's not effective, right?
Right.
Yeah, I thought,
If there's a subsidy issue at the clinic, if you have a client, there's a subsidy issue, either they're an applicant or they have a subsidy, that's time to contact whatever the legal services person is who's in order with you. Because those issues are very particular and a very narrow set of federal law and federal regulations. So that is really a time to be careful and say, look, let's find the legal services attorney, let's sit down and talk this over so I can be sure that the advice we're giving you about what you're about to agree to is not going to mess up your subsidy.
or even if
And
they're on a waiting
that would
list.
apply to other types of benefits too, because people can have problems with other types of benefits in terms of eviction. So
And sometimes
that's one of the reasons that it's important that there are going to be legal services attorneys who are there, because the benefits side of it is something that you really want to ask for help on.
And even if if it's a really just heartbreaking situation, I think you didn't even know that I was there. I was invisible in the background. I think Nadine was representing a landlord who was evicting someone for non-payment, but the person had to quit her job because she was diagnosed with cancer and was told by the doctor, you quit your job while you're in chemo or you're gonna die. And so that's why she didn't have any money to be able to pay. And the hospital social worker called me and said, Housing Resource Center won't help this person because she has no hope of future income right now. She doesn't get Social Security yet, blah, blah, blah. And she's gonna be homeless fast. And so I called the housing authority and they're giving her an we just did all this crazy stuff so that she's just gonna move on out. It didn't even come into court, right? But it's knowing and it's so hard to know all the people to call and how to work that stuff, that if you get some incredibly sympathetic situation like that one was, or if it's a person who's on a wait list or has some sort of benefit already, it's important to reach out for help in those cases.
But, and when there's a lot of questions that you need to ask the tenants, because like Jessica was able to get this particular tenant a voucher, but the housing authorities have what are called preferences. So domestic violence, this was a medical need. So I get a lot of tenants who are victims of domestic violence, and the partner moves out because they're on a relief from abuse order, the rent can't be paid. So you do see that as well. So you just need to know the tenant's circumstances. And as far as being able to pay, this clinic is starting in February, which we're going into income tax refund time, which is always a great time. So it's kind of a slow in the landlord-tenant world. It's just crazy, but we
love it.
We start at school close in the fair, and then we come into Christmas, and they're way behind, and then we come into tax season. So ask them if they have a tax refund coming back. You would be surprised how much money some of these tenants get back.
Even if you had some crap job paying you minimum wage, that earned income tax credit is fantastic. They're getting thousands of dollars.
Nadine, I'm getting $6,000 back. Really? All right. Well, I'll hold off asking for a final hearing until after March, which I have a lot of these going on now. And if they pay with their taxes, then that's great, because they've gotten new jobs and they're able to sustain the housing, but tax time is a great time of year.
Also, if your client happens to be a student, we had one case recently where my person was a student and hadn't taken out any student loans. She was just struggling with her income to pay for everything.
Yep.
Take out the student loans, pay your rent, gone. Pays over.
She has student loans, yep.
So, really talking to your client and just seeing what are their circumstances. I've had other clients be able to get, where it was like a minor amount of money, get an advance from their employer, one paycheck, case done,
I
right?
just had one tenant. She literally, the sheriff was coming the next day. She owed, it was like $2,600. Her employer called me literally hours before and said, I will pay it. Fine. He came over and he paid. So ask them to explore their employment situations, because there are a lot of really great employers out there that will either loan the tenant some money or help them out. If you have a tenant that works at Fannie Allen or for UVM Health, they have a special fund. They have the Leroy Fund that helps employees. So is there an employee fund that can help them, which is and it's out there. There's a lot of money, there's a lot of pockets out there. You just, if you can help them as part of your representation to send them in the right path, they have to go ask. And if they ask, I find that the tenants who make the effort, recently I had a case, I think I had 8 different funding sources, and I will work with all the funders. So if they say, I'm going to send X amount of dollars, I know it'll come, and then once we have it all, then the eviction's over. But some of these people just need to get back on track, and once they're on track, they're fine. Or you've had a tenant that has lived there for 7 years without a problem, and something happened, the car broke down, or they couldn't get to work, and the kids got sick or whatever, and they just need to step up. These are the people that need the help and that are good tenants. So.
Yes?
If a rent escrow order issues and then the tenant, say, pays the full arrearage a week later, is that whole case then gone because it's cured, the rent escrow order goes away, and we're started back at square one?
You're going to have to file a motion to dismiss. It's not just going to go away automatically. But yeah, if you cure your arrearage, then, and there were no other issues, just a non-payment, then you're going to be.
I mean, my practice is if they pay everything, I file a dismissal immediately. So.
Well, just be aware though that the statute says pays the rent to the day you file the motion. So it's not just past rent. I suppose you could credit rent that's been paid into rent escrow already. But also court costs, which include sheriff's fees and interest on the unpaid rent. So technically speaking, if you're filing a 4773 motion and Nadine is not the landlord's attorney, you have to have a technically correct motion, which would require the payment of all those sums.
And the tenants, the agencies usually do not help with the court costs. But what the statute says, you have to pay the back rent, the court costs, the sheriff's fee, the filing fee, and they all have a heart attack at the $265. We don't charge interest, but you do need to check to see if that particular landlord is going to charge the interest on what's owed. We don't, just to make math easy, but.
I could see how in a month-to-month lease situation, this could go on for a very long time, if you buy a long time. What about, what percent of your leases end up being, say, 1-year lease, at time certain, and if you're 10 months into the lease, does the tenant have any right after the lease is terminated by its terms to continue to occupy?
Oh yeah, unless the landlord sent them notice saying, we're not renewing your lease, you're terminated as of the day that your lease ends, then they can stay.
But I thought, maybe it's just my property 101, that if the lease says in clear and plain terms, your lease terminates on 12/31/2014. You have no right, there's no renewal rights, blah, blah, blah. It's done.
Holdover tenant. You stay.
Doesn't matter what the lease says. The law is.
And is that the state or the city of Burlington or both? Do we
The
think?
whole state.
It's
the
the Vermont
state
Supreme
says-
Court, in fact.
So then,
That's actually common law in Vermont.
Yeah.
And that actually precedes the Residential Rental Agreements Act. If you stay on, the landlord defeats that by saying, this tenancy is over at the end of the lease term in our lease.
Right.
The tenancy is terminated as of that date. And that's a clear instruction that everything's over. If there's no such
Clear language.
thing coming from the landlord, then they become a month-to-month tenant at that point, and that's basically common law.
Under the same terms of the lease that they had.
And there's no written lease that says this lease ends on this date, period. Sometimes they require, they convert the month to month. Occasionally, they'll say absent notice or something like that. But I've never seen a written lease that just says, this lease ends, period. You move out on, such and such a day.
Even if it did,
The court has said,
It doesn't matter.
it doesn't matter.
yeah, and what the court has said is that payment of rent by the tenant and acceptance by the landlord creates a new lease.
I was just thinking of a situation where I see these leases all the time where they go from June 1st to May 26th. And it's very clear in the lease that you have no rights after May 26th at noon so that the landlord can get in and clean up for the next tenant. So you mentioned common law and you mentioned statutory law. Which is it? Where do we find the overturning of the written lease that says a lease ain't a lease?
Is that the college
Yeah.
students? Yeah. I always tell clients who have college kids in their units, if you don't want them there and you don't have a renewal that you've worked out months in advance, then send a notice a few months before just to be clear that you want them out, just so there's no doubt at all.
And that's the magic that will actually make the lease work in the way it was intended to work.
It'll
Assuming they
terminate.
leave.
I was gonna say.
So if they don't leave, you still have to come to court.
Right. Yeah, right.
I mean, it is not magic.
Yeah.
Right.
So we only have 15 minutes left.
Oh, I better hustle.
want to prioritize.
Okay, so,
The defenses are good.
yeah. If there's a non-payment case that has habitability defenses, and again, this is for a tenant who wants to stay where we're not just trying to work out a move-out deal, then I'll, put on as much evidence as I can about the habitability problems in the unit. So if the tenant miraculously has town health officer reports a report from Bill Ward here in Burlington, then I'll want to show that this place isn't worth the rent that was being charged. So I've had a couple of results from that, either that the tenant didn't have to pay rent until the landlord could show that repairs had been made, that the hearing was, I think once Judge Crawford continued the hearing until the landlord could show that the repairs had been made. And in some cases, the judge would just reduce the amount of rent that the tenant had to pay if it wasn't something like no heat or no water and that kind of thing. So trying to get it to be less than the total amount or down to nothing if there are those habitability issues. And if your client hasn't actually had someone come document what those issues are, get someone in there really fast, because I'm not going to do a tenant says, landlord said about what the problems are. I'm going to have some expert tell me what the problems are.
Habitability is clearly defined in 9 VSA 4457, so that's your whole habitability defense right there. So it gives you attorney's fees, damages, et cetera, for legitimate habitability claims. So you do need to know what the condition is of the apartment when you interview the tenant.
And if I can just add, habitability is a defense in the ultimate case, but it also can be used, at least with some judges, including me, at the rent escrow hearing, as she's saying. Some judges, if you're doing this project a year from now, another judge may say, I don't address habitability at the rent escrow hearing. The statute isn't clear about that, but I do, and I'm happy to have you raise those issues. But it's also something they need to address for the trial.
And even if the judge says, I don't want to hear about this right now, you won't have time, obviously, before these hearings when you're doing the clinic, but you can later file a motion to have the amount of rent escrow reduced and go through all of your many reasons why the tenant should not be paying the $1,300 a month or whatever it is that the landlord is charging them because of all the problems in the apartment.
And it has to be for existing problems, not, say, for example, if you come in June and the tenant's saying, for an escrow hearing, the tenant says, I have no heat, it doesn't matter. So if you come in January and they have no heat, then you have a legitimate claim to bring at the escrow hearing for reduced rent.
So let's move on to answers, defenses, counterclaims, etc. Habitability is one of the big ones. It requires showing a defective condition that is a material threat to health and safety, that the landlord failed to remedy within a reasonable period of time after actual notice was received. Actual notice generally being notice in writing, either from the tenant or from an inspector. If it's from an inspector, it could just be verbal. But very interesting here. There's a case, Terry and Terry v. O'Brien and O'Brien, 1382-12-11 CNCB. in which the landlord was made strictly liable for latent defects in the apartment. And that case is currently on appeal to the Supreme Court. Look out for the friend of the court brief that I'm probably going to write. And I also make an argument that failure, and this is untested, failure to comply with the Vermont lead law. The lead law puts landlords, it requires them to go in and inspect to see if there are any defects with lead paint. And so I make an argument that it forces the notice. So even if the tenant didn't put the landlord on notice that there were problems, the law required that the landlord put himself on notice. So I try to get around that actual notice issue that way. Again, not tested.
And I just said that in almost all, whenever you want to plead habitability as a defense, you want an inspection by somebody.
Yes.
You can't just rely, I mean, it's a very unusual tenant that has real proof sufficient to show that there's a violation of the warranty of habitability. So that's another of the questions. Has this been inspected? Did you call the building inspector? What did they do? Did they file anything? Did they give anything to the landlord? That's key.
And if they haven't done it yet, do it now.
Yeah.
Yeah, and there are, just a heads up, in addition to, the city folks, Bill Ward, there are a number of different inspectors that you might be calling in. Agency of Natural Resources for toxic waste that the landlord may have dumped in the backyard. Yes, I've seen that one. And Department of Public Safety to inspect the knob and tube watering or whatever might be in there. And there is one lead paint inspector for the entire state. So again, I mean, I'm never going to want to do those cases unless I have lots of reports to back me up, because I really don't know a lot about plumbing. So
what about retaliation?
We're getting there.
Do
We're getting
retaliation,
there.
and I think we should probably close.
Oh, yeah, I'm running out of time. Okay, so
I know that there's a
quickly.
finesse too, that in Burlington, Rutland, Bennington, Barry, certificates of occupancy are required prior to renting the apartment. The failure to have a certificate is generally sort of an inkling that something's wrong with the apartment, that the landlord's trying to do a dodge. And that will usually, if there's no certificate, it's a good time to call the inspector and see what has gone on prior to the tenant. Because you may find your notice in, years-old inspections all saying the same thing.
Another defense that's commonly raised is violation of the Consumer Fraud Act. If the defective conditions existed before the tenant even moved in and the landlord knew about them, then that's a reasonable counterclaim to make that the tenant should get back all consideration paid, i.e. all rent paid.
It's big damages for Consumer Fraud Act.
Yes. Retaliation. If the tenant did actually complain to an inspector and then the landlord said, I'm evicting you for no cause, you have a really good retaliation defense. The landlord can't no-cause someone just because they complain to a health inspector, and there's going to be a presumption, unless there's also a non-payment issue, that within 90 days of that complaint, that a no-cause isn't valid. Another thing that I always ask my clients about is any personal injury, even injury from bed bugs, which are pretty gosh darn common now. And a lot of the times, I'll just talk to my opposing counsel if there were personal injury claims, because they don't want something to be filed with insurance, and so we'll just work something out.
And sometimes we do get to work with Walter and other defense counsel if there's a fall down the stairs or they slip down the ice or something. So you get personal injury and your landlord tenant, you try to get them both resolved. But it does happen.
I think one of my first cases was
Those
with
are
Walter.
probably mandatory claims.
Yes.
In an eviction. In other words, if there's a personal injury claim, that's a mandatory claim. You can't raise it later if you didn't raise it in the eviction.
I'm also going to talk to my client about whether or not the landlord has been trespassing in their apartment. Landlord entering the property absent exigent circumstances and without notice and permission is trespass. Illegal eviction, which we talked about earlier, discrimination, any Fair Housing Act claims, failure to offer requested accommodation, etc. Intentional infliction of emotional distress, landlord in Jericho, putting a sign out on Route 15 saying, honk your horn as you pass my crappy tenant's apartment. No, can't do that. So yeah, those are the big ones that I'm going to be looking out for. There were a few other issues that we kind of hope to be able to talk about, but we don't really have very much time, do we, to talk about reopening a case after default, motion to stay, execution of a writ,
Which is for clinic
trials, and that'll be clinic too, right, and writs of possession, et cetera.
But you mentioned lead poisoning?
I did mention lead poisoning,
Okay.
very briefly.
Okay.
But yeah, those can actually be, I encourage you, take those cases for money, right? Like, you can get decent judgments and or settlements on the lead paint cases. So those are cases where the apartment wasn't in compliance with the lead law, and usually a child under 6 can end up with an elevated lead level, which can cause permanent brain damage. And so even the parent can go after the landlord for rent paid and emotional damages, et cetera, along with the child having their own claim. Tom, are you going to talk to us a little bit about forms to make your practice easier?
I'm going to send people forms or access to forms because you'll all hear from me because I don't read your emails. But I think we'll give the judge the last word.
And I do just want to say, I've written I've written so many motions.
Here she goes. Here she goes.
Ask me questions if you, or I'm here to help.
So thank you all so much for doing this. This is wonderful. I do know that this sounds like a lot of information, and it's more complicated than you thought, right? Landlord-tenant law is actually pretty complicated. But I do want to remind you that that's why we're going to have the lawyers from Legal Aid or Lawline here to help you, so that when you have a question like this, you don't just have to figure it out on your own. The other thing is, I know there weren't enough copies of everything because we really didn't realize how many people would come, and I'm so glad we had too many. But what I'm going to ask the presenters to do is to put together an email with all of their handouts, and then we can email them out to everybody so that anyone who didn't get it will get them. Who has the clipboard? Okay, so how filled in is it?
You've got people who want to come in April.
Yes.
Overflow.
All right, we're happy. We were just kind of guessing that having 3 people at each clinic was a good number. We'll see how that goes. We may decide it's not enough, it's too many, I have no idea, so we're just going to wing it. So if you have other questions, I'm sure the panelists are happy to stick around. I'm happy to answer questions too. If you have to go, go. But thank you all so much for coming, and let's make this work. Thanks. Oh, and one other thing you should all know. Donna Sims, right here. She is the person in the clerk's office who deals with these cases, so be nice to her.